Court officer, audio idea. Court officer.
Sir, ಹೇಳಿ sir.
Audio ಇದೆಯಲ್ಲ?
ಇಲ್ಲ sir.
ಕೇಳಿಸ್ತಾ ಇದೆಯಲ್ಲ?
ಸರ್ ನಾ ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ ನಾವು ಮಾತಾಡೋದು ನಿಮಗೆ?
ಹಾ, ನನಗೆ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಹಾ ಸರ್, ಆಡಿಯೋ ಇದೆ ಸರ್. ಆನ್ ಮಾಡಿದ್ಯಾ? ಇನ್ನೇನು ಕೇಳ್ತಾರೆ?
Filed application for early hearing. Admission. Which year?
Matter has been admitted, but application for stay has not been considered yet. Another matter of 2010. It may come in the usual course.
Final hearing.
Final hearing. Yes, sir.
Application to file application. Request.
7.
Which time frame?
Serial number 30.
Request to which time frame? Serial number?
35.
Ah.
Now for the appellate, seek a 1 week time in the study.
Which? Let I request.
Serial number 45.
What happened? 2006 matter.
AGM has transfer, given the resignation, nobody is there. I leave it.
2000
Find the house from
2006 matter.
45.
2006 matter. 45, yes.
5422.
Which court you are in? Which court? Which court? This is 29.
Lordships kindly, madam.
Page number 60. Tomorrow, tomorrow.
63.
Tomorrow.
The request of learned counsel for the appellant is this matter tomorrow.
Lordships kindly, madam. Serial number 46, madam. May I request for short accommodation, madam.
46.
46. Hearing matter, madam.
Is it parted?
No, madam. That is there for tomorrow, madam. I'll go on with that case tomorrow, madam.
On which matter?
Either Monday or third. Your Lordship may have it on second, madam.
Request of learned counsel for the appellant is this matter on third. Third.
Obliged.
Abhishek. When this publication was ordered?
Last week, I was asked to carry out publication by 7th of October. By 10th of October, carried it.
In terms of order dated 20th September 2022, the petitioner has taken paper publication. The citation published in Hindu and Prajavani daily newspaper are produced before the court. They one are published before the court. Are produced before the court. We have to need evidence. Based on will, you are seeking probate. Need evidence.
Directly with the order. Once paper publication is ordered, there is no responses.
The new procedure is being followed. But need the evidence of one of the testing witnesses before the madam. Computer project coordinator.
Office has raised one more objection.
What is
They
that?
put a note saying I have to seek a dispensation of notice.
Not filed application.
Application. There are only bank accounts. There is no property involved for which the valuation has to be done by the deputy.
How much court fee you have paid?
Maximum court fee is payable in this matter. It's 1 crore man. Anything above 9 lakhs.
Learned counsel for the petitioner submits that he has paid the maximum court fee payable in this case. And he also submits that no immoral property is involved in this case. As such, notice to the deputy commissioner is dispensed.
When my court fee is paid after probate is ordered, I am not paid. I undertake to pay.
Not yet paid.
Not paid.
Learned counsel for the petitioner undertakes to pay the maximum court fee. Is this matter before the CCP and number of for recording the evidence of the petitioner and witnesses. Yav 8 now. Withdraw. Learned counsel for the petitioners files a memo to withdraw the petition. Memo is taken on record. Petition is dismissed as withdrawn.
The application. application filed to leave the procedure and pass over season. This is regarding the application which is filed for leave to prosecute.
Do not party before the proceeding,
Party before the executive.
executing court,
I filed an application.
seeking permission.
The enlarged
What is the office objection now? Are you sure that is that? How do you say? Password.
The last occasion they have submitted.
ಸರಿ, ನಿಮ್ಮ ಹೆಸರೇನಮ್ಮ? ಗೌರಮ್ಮನ? ನಿಮ್ಮ ವಕೀಲರು ಯಾರು? ನಿಮ್ಮ ವಕೀಲರು? ಬೇರೆ ಅಂತ ತಗೋತೀರಾ? Appellant number 1 is present before the court. She seeks recommendation to engage another advocate. This matter. ನವೆಂಬರ್ 17ಕ್ಕೆ ಬೇರೆ ವಕೀಲರು ಕಟ್ಕೊಂಡು ಬನ್ನಿ. ನವೆಂಬರ್ 17 ಅಷ್ಟೊಳಗೆ ಬೇರೆ ವಕೀಲರನ್ನ ಕಟ್ಟಬೇಕು ನೀವು. Password. When memo is filed?
Hearing for appellant in this case.
10.
Yes, for 2 weeks for filing necessary application in this case.
The sole respondent died.
We are not aware of they are not intimated about this.
Quoting the death of sole respondent, Learned Counsel for the appellant seeks short recommendation to take necessary steps. 2 weeks time. Yes, 2 weeks time granted. Three weeks time granted to file the paperwork. What are the office objections?
Second appellant is died.
Solve it today. During the course of the day. Password.
Respondent number 1 and 4 to 7.
Time may kindly take that with us.
These are not so only was underneath of grave.
Learned Counsel for the appellant seeks. Learned Counsel for the appellant seeks a week's accommodation to take necessary steps. Granted. Week's time granted.
Lordship, kindly grant 4 weeks time. Shall file paperwork.
3 weeks. It's on learnment. 3 weeks time granted to file the paper. Password. Possible.
Well, appearing for the appellant. I have it after 10 days, but today I have some inconvenience because I don't have file. I have shifted recently the office. So file is missing. And also office objection. Already party in person appeared before this court. And also there is an order, the notice is held sufficient. In spite of that, this repeated objection is coming.
No, the note says you are not yet filed the acknowledgement for having served the summons to respond number 1.
That I will see after getting the file. But as far as the service is concerned, held sufficient.
For the appellant. This matter after 10 days.
Much of
What is the office objection?
If there's some clarification with respect to office paper book.
You have got any objection?
For respondent.
I don't know what.
You appears for the appellant.
I'm appealing for respondent. Sir.
Seal number 14.
Yes, sir.
It's possible. Weeks time granted. 3 weeks time granted to file the paper.
On 16, I appear for the respondent.
3 weeks time granted to file the paper book.
First is if subject to court, and date may be fixed.
2011 matter, let them file the paper book. 3 weeks time granted.
Please.
Now they are going to, you are for respondent or appellant?
And told that the selected matter has to be filed.
Let him file paper book. We will dispense. Once it is filed, we will dispense. 3 weeks time granted to file paper book.
Lord,
Yes.
I appear for the.
Yes,
Lord,
what correction?
Lord, I have filed this application for correction of some mistakes in the judgment, my lord, and decree. Lord, kindly take your Lord, application, my lord.
Yesterday I filed the objection, Your Lordship.
Lord, application in prayer 1, my lord, to order correction of the mistake in the last sentence of para 32 of the common judgment dated 28/6/2021 as 2/5 share in the place of 2/13 share, and also to order the correction of the extent of land in survey number 195/4 as 1 acre 14 guntas in the place of 1 acre 1 gunta.
Just a second. Just a second.
Then, my lord, in
Just a
the
second. Just a
decree, my lord, this
Judgment. Where is the judgment?
in this decree, my lord, survey number 195/4
Just
was
a second. Just a second.
yes.
But this order is not passed by me.
This order is not passed by your lordship, my lord, but Lord, the lordship has retired, my lord. Therefore,
Just a second. You have filed objection?
Yes, I already filed the objection yesterday itself.
Is it typographical error or what? Is it typographical error?
No, Your Lordship, it's not a typographical error.
Hmm.
Their contention is that, so in the appeal, they raised that one more property was there, which is standing in my father's name, so which is not included in that. Your Lordship, kindly see that this honorable court is not given any finding.
Gopal, Mr. Gopal,
yes,
Gopal, if this is not a typographical error, then probably you may have to file a review petition.
my lord, your lordship, I kindly see, my lord,
If
this is the
typographical error, then application for
my lord,
correction would lie.
decree is not in conformity with the judgment, my lord. Kindly see para 27, my lord, 7 and 8. Decree should be in conformity with the judgment, my lord. Para 7 and 8 may kindly be seen, my lord.
Just a second. Are you seeking correction in the judgment or in the decree?
Decree also, my lord, decree.
No,
Let
decree
us-
understood.
Yes.
Are you also seeking correction in the judgment?
Correction in the judgment, my lord, 2/5 share is granted to the purchaser, here, which represents, my lord, 2 vendor share. In all other parts of the judgment, my lord, it is 2/5 share. In only one sentence, my lord, in para 32, it is stated that mistake, my lord. It is a typographical mistake. As against
All right.
2/5 share, 2/13 share is mentioned, my lord. All other paras, my lord, it is 2/5 only. It is a mistake, my lord. Typographical mistake, my lord. Your lordship may. First, your
Where do
lordship.
Where do you get a finding that he is entitled to 2/5
Yes,
share?
my lord. Kindly see, my lord. Para 33.
No, that is understood. In
Para
33,
24.
just by 13.
Para 33 and para 24, my lord. It is a typographical mistake, my lord. Para 33, my lord. In so far as defendant number 13 is concerned, that is myself, my lord, appellant. It is connected to RSA 29. Your lordship got, my lord.
Which page? Which page?
Internal page 35, para 33, my lord.
Insofar as, yes.
Yes, in so far as defendant number 13 is concerned, it is connected to RSA 2909. In the circumstances, it is established that he has purchased respective properties for consideration. His vendor were entitled to the scheduled properties. However, by going by the principles of joint family and equity, his entitlement cannot exceed 2/5 share in the joint family property. That is 1/5 share of Ujjappa and 1/5 share of Ningappa. But in the previous para, your lordship may kindly see, my lord.
Yes.
Yes, previous para, my lord, para 32. Para 32 also says, my lord, 1/5 share plus 1/5 share. But in the end, my lord, a typographical error has crept in.
Typographical error.
No, your lordship, only one. See, the decree was confirmed, 1/5 share was allotted. See, the court is not directed the trial court to include all the schedules which were, because that is not the schedules which were earlier in the plain.
This court is not concerned with the schedule. This court is only concerned with the arithmetics.
Yes, 1/5 share, we are not disputed with respect to 1/5 share. What they are saying is that include the one schedule which is left out in the earlier decree.
Well, the 13th defendant is myself. In all other paras, my lord, it
We are
says
not disputed the 1/5 share on itself.
See,
only in para 33 end.
Yes.
Para number 33.
Yes.
However, by going by the principles of joint family and equity, his entitlement cannot exceed 2/5 share in the joint family properties.
Yes.
It is 1/5 share of Ujjappa and 1/5 share of Ningappa.
So we are not disputed that.
Mr. Gopal, are you applying for purchase, sir?
Yes.
Yes, purchase, my lord, appellant.
Just a second. Just a second.
Appellant, judgment was
Just a
modified,
second.
my lord.
Just a second.
Yes.
Have you purchased the property from Ujjappa and Ningappa?
Yes, my lord. Kindly see, my lord, para 28 also.
Just a second. Just a second. Have you purchased property from Ujjappa and Ningappa both?
Yes, my lord, yes. That is the finding.
You admit this fact?
Yes.
Then that is understood.
The only
So,
thing is
it
that
has- it has
we are
to-
not with regard to the 1/5 share of that share.
2/5. See, in case if
Yes.
you purchase 2/5 share,
Yes.
1/5 share of.
2/5, we are not disputed at
So,
all 2/5 share
Just a
of.
second. Just a second. In that event, para number 32, last sentence. How it is 2/13 share? It should be 2/5 share.
Yes.
2/13. Okay, 2/5 instead of 2/13 ಆಗಿದೆ. ಅದನ್ನು 2/5 ಮಾಡಬಹುದು.
Yes. Next.
Then, my lord, one more aspect. Kindly come to, my lord, para 7, my lord, para 7. With regard to, my lord, the inclusion of one item. I have raised objection, my lord, in the appeal that this property, which is joint family property, is not.
Just a second. Just a second. Para 7.
7.
Ah.
The suit schedule properties for 3 items earlier when the matter came up for final disposal before the trial court, which are as under. Item 1, 2, 3.
Yes, yes.
Then, my lord, your lordship kindly come to next page, my lord. Next page. So and so. That is, my lord. Yes. However, one more property was added before this court to the suit schedule through an amendment application under Article 6, Rule 17, which
Yes.
can be allowed by this court. It is necessary to clarify at this stage itself that in the light of the claim of third defendant regarding non-inclusion of fourth item property, learned counsel for the plaintiff is my
Yes.
learned friend. Final
Yes, yes.
application seeking permission to amend the suit
Understood,
schedule
understood.
property, and accordingly, fourth item
Yes.
was
Yes.
added to the suit schedule property, which is as under all part
Understood.
and parcel of survey number 195/4, measuring 1 acre 14 guntas. My lord,
Yes.
boundary is also given. Then your
Yes.
lordship may kindly come to my lord para 24, my lord, para 24. He accepted that, my lord, para 24 with regard to that item, my lord. 24. Your lordship, kindly see, my lord, para 24, your lordship got, my lord. After hearing the learned counsel for the parties, the existence of joint family is not disputed. Next comes the suit schedule properties. In this connection, learned counsel for appellant R. Gopal in RSA so and so raised the issue of non-inclusion of properties and submitted the two properties are left over by the plaintiff, which is the land bearing survey number 195/4, measuring 1 acre 14 guntas, and thrashing yard, which is sold in favor of Peribasaya in the same village. Learned counsel for the.
Yes, understood.
Yes. Then, my lord, your lordship may kindly
Para
see
25, yes.
para 15, my lord, 25.
Yes, I read it.
ಇಲ್ಲಿ 1 ಎಕರೆ 1 ಗುಂಟೆ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಈ ಪ್ಯಾರಾ 24 ಎಂಡ್ನಲ್ಲಿ ಅದು ಮಿಸ್ಟೇಕ್ ಅದು. 1 acre 14 guntas, that is not in dispute. Next, my lord, your lordship kindly see para 25. My learned friend has said he sold it. That plaintiff has sold it. He said, nextly, the purchaser to whom the plaintiff sold the land in survey number 195/4 to the extent of 1 acre 14 guntas, he is not made as defendants. Further, learned counsel Vinay Kirti, my learned friend is appearing now, submitted that the said portion is sold to Sanna.
Yes, understood.
Then we are trying to see the decree, that is not incorporated in the decree at all.
Last item.
Yes, last item. Fourth item.
Yes.
Only one submission in that aspect, your lordship. Now that your lordship, all the parties.
You are the plaintiff.
I'm the plaintiff.
You included on property by way of an amendment. That should be the part of the decree.
No, that is not become the part of the decree.
That should be. Why did you amend?
So only
That is
thing,
your application.
yes, I'm not disputed that. My only contention is that in that 114 also, all are equally entitled for the equal share.
The court is not going to that aspect. In this correction, the court only says all the plain schedule properties are not included in the decree. That one correction you will order. And as far as this typographical error relating to 2/5 and 2/13, that will be correct. The fourth item will be part of the decree. You included. It is your application.
I'm not disputed.
And what you are saying is, just a second, what you are saying is, that property should be allotted to your share because you already sold.
Yes, my lord. That is it.
But in an application like this, you should say no objection.
Only my objection is that your lordship, they filed after the completion of the FTP proceedings. Now the FTP proceedings is already over.
Whenever an error is brought to the notice of the court, whenever an error is brought to the notice of the court,
1 year delay is there.
you should be graciously, you should have said, I have no objection. In the first instance, you should have made an application.
That is only objection I filed.
You are the plaintiff, you should have made an application. Third, the learned advocate appearing for the appellant and the respondent on IA number.
And IA number 1 of 2022.
1 of 2022. For correcting the judgment and decree dated 28 June 2021. High Court in terms of order dated 28 June 2021. Appeal ಏನಾಯ್ತು?
Appeal allowed, my lord. Judgment and decree of the RA court was set aside. It is modified, my lord, saying that I am entitled for 2/5 share, and in equity I have to work out by including 1/4 item of the property. In fact, in the decree, my lord, it is mentioned as 2/5 share only. Only that para 32, my lord, there is mistake. That is taken of advantage of in the FDP proceedings. My lord, I have filed appeal against the order. They try appeal in the FDP. It is said, my lord, that 13 share is allotted. That is a mistake, my lord. Some technical problem, my lord, in the. some technical problem. Some technical
Dinesh reads that he was aware of the existence of the lease agreement dated 6/9/2001. I got the fact I put it in that. 6/9/2001 and filed on 39/2011. ಅದು ತಪ್ಪಾಗಿದೆ ಡೇಟ್ ಹೇಗೆ ಬಂತು ಅಂತ ಗೊತ್ತಾಗ್ತದೆ. ನಾನು ಇಟ್ಕೊಂಡು ಅದನ್ನೆಲ್ಲ ಮಾಡಿದ್ದೇನೆ.
Just a second. Dinesh reads that he was aware of the existence of the sale agreement antidala.
That is right. That is where the learned judge.
Just a second. You have pleaded you are not aware.
I was not aware. I was not a party. That was my contention. Otherwise,
Show the plaint.
yes. Defendant number 1 and 2 are the agent of restricted property and are not the owners of restricted property. Defendant number 1 and 2 contributed together in contribution with defendant number 1. Entered with defendant number 2 formed a document of an agreement of sale dated 6/2009. That agreement of sale is contributed one with the conveyance between defendant 1 and 2. The agreement of sale between defendant 1 and 2 is a bogus one and that document. Defendant number 1 on the bogus agreement of sale dated 6/9/2001. Filed as before the honorable division and so and so. And it is made over to additional division so and so. Defendant number 1, the OS 186 of 2002 with a prayer for the performance of the agreement of sale. Defendant number 2 appeared and not filed a statement and not defended evidence. Hence the suit OS 186 of 2002 and the decree was drawn.
Sir, you have to be very specific. This is review.
Yeah. By that time, the scheduled property was purchased by the plaintiff under a registered sale deed dated 28/2002. Plaintiff in this suit is a bona fide purchaser of the suit property. While at the time of filing of suit was 86 of 2002 by Sekundaram, defendant number 1 in this suit knows that suit scheduled property already sold to this plaintiff. Plaintiff not at all arrayed as plaintiff. RD was 186 of 2002.
Did you say that you are not aware of this agreement? Where did you say?
Yes. What has been stated?
No, you never said.
No,
You never said that. No, you never said.
Plaintiff purchased social property from the second defendant for a sum of 12/2002. If the date of purchase of such property, the plaintiff is in possession and income of property. RTC of this social property is standing in the name. Data has been entered in the name of plaintiff. Therefore, the plaintiff is the absolute owner of the rightful owner thereof and is enjoyment of the property. Defendants 1 and 2 are stages in the property and are not the owner of the property. Defendants 1 and 2 collaborate together in possession with defendant number 1, entered with defendant number 2, formed a document of an agreement of sale on 2001. That agreement of sale is a different one. The alliance is defendant 1 and 2. Agreement of sale 1 and 2 is a bogus one and signed document. Defendant number 1 of the bogus agreement of dated so and so. Filed as before the honorable division and the investment number so and so. And it is made over to so and so. This is what has been stated.
No, where did you say that you are not aware of the previous agreement?
Yes, the defendant number 1 filed a suit against this plaintiff and others invoice 85 of 2003 before this honorable court, and in the said suit was dismissed as so and so. In view of the memo filed by plaintiff invoice number 10, the suit for declaration and permanent injunction. Other factors so and so.
Yes, then
It is not there.
then without pleading, how can you raise a point?
No, my submission before this honorable court. Yes, I understand. My submission is
Still, though there is no pleading, a substantial question of law has been framed and that has been answered. Maybe rightly or maybe wrong.
that is where this trouble has
you can say that substantial question of law should not have been framed.
No, substantial, it is the jurisdiction of the court to claim substantial of
No,
person.
there is no pleading at all. See, you have not raised a defense of bona fide purchaser without notice to the previous
No, no,
segment.
I have contended.
No,
I am
you-
a bona fide
just a
purchaser.
second. You say that you are a bona fide purchaser.
Yes,
You don't say that you are a bona fide purchaser without notice of the previous agreement. There are two aspects. Saying bona fide purchaser, you are saying that, yes, I really believe that my vendor is the owner of the property. That is one aspect. Bona fide purchaser for value without notice of the previous agreement should be the specific defense.
no.
That is not there.
I'll just submit. Bona fide purchaser without the notice, bona fide purchase indicates that I have
it
made,
may
no, I have
indicate
made
many
all
things.
possible efforts to verify the title of the vendor, and I was carried away by the entries in the revenue
See,
records.
in
and
para number
the-
27, just a second, in para number 27, the learned judge of this court says, the contention of the present petitioner, that is the defendant, gives different inferences. So your contention relating to bona fide purchase gives different inferences, that you bona fide believe that he is the owner. You bona fide believe that this is the real value of the property. So many things. There is no specific defense that you are a bona fide purchaser for value without notice of the agreement dated so and so, or previous agreement.
No, no, 1 minute. Just kindly permit me. In the other case, that is the counter suit, this contention has been taken. I will read that.
And ನೀವು ಹುಡುಕೋದು ಬೇಡ, ನೀವು ನೋಡಿದ್ರೆ ಹೇಳಿ. You have to be very specific in review petition.
ಅಲ್ಲ, ಅದನ್ನೇ ನಾನು I do not want to waste the time of the court. Therefore, I want to be very specific. In fact, ಏನಾಯ್ತು ರಾತ್ರಿ I did not look into the cast title ಇವತ್ತು ಬೆಳಗ್ಗೆ 5
All right, if you are not fully prepared, we'll have it on Monday.
Wednesday.
At the request of Honorable Counsel for the petitioner, list this matter on Wednesday.
Okay, my dear.
See, if the defense is not there, bona fide purchaser for value without notice of the previous agreement, then there is no scope for review.
Wednesday.
It will be a good case in SLP. Yes. Huh? Wednesday.
24 and 25, there is both.
26.
Previous date, my lord, they had stated that they will be withdrawing to.
Get them, pass out. Yes. Yes.
Respondent. Right, that's good. Where number 158 for 19. Of course, performance of. Unregistered registration of unregistered infringement deed said to have been executed by the first defendant in favor of the plaintiff.
Mother.
No, they are sisters. Plaintiff and the first defendant are sisters.
ಒಮ್ಮೆ hearing ಆಗಿತ್ತೆ ಅದು? Once it was heard?
I did that.
All right. Agreement dated?
Let this relinquishment deed dated. I will give the date. I will give. 24/6/1999. I'm sorry, food file. Relinquishment deed is 7/6/1988.
7/6/1988. Relinquishment date between whom?
The first defendant.
Relationship.
Sisters, they are full sisters.
One sister executed in favor of another sister.
Yes. They got this property, under a gift deed executed by their mother on 10/2/1944. On 10/2/1944.
Gift by mother on 10
Mother, in favor
1944.
of her two daughters.
In favor of two daughters.
In respect of the social property.
All right.
4 acres and
Yes, all right.
Thereafter, my lord, this is the
Relinquishment deed. Relinquishment deed.
relinquishment date alleged to have been executed by the first defendant in favor of the plaintiff.
What is the consideration?
Consideration is about 55,000. 35,000. Unregistered matter. according to the plaintiff.
No, this is an agreement to relinquish or relinquishment deed itself.
No, my lord, it is not an agreement to relinquish. It is a relinquishment deed itself.
Okay.
But subsequently, this honorable court, my lord, in CRP held that this has to be treated as an agreement to
Relinquish. The entire consideration amount is paid.
Yeah. Then, my lord, the suit was filed by the
Specific performance.
seeking for execution of the
Yes.
deed.
Yes.
And she did not seek further prayer as required under section 34 of the Procedural Act or Possession Act. Now, my lord, in respect of the suit was partly decreed, and in respect of the defendants, 3 and 4, suit was dismissed.
Who are 3 and 4?
3 and 4, 3, my lord, is the son of one Rangappa. He is a relative of the plaintiff and first defendant, who has been in possession and enjoyment of municipal property in respect of 1 acre 37 guntas and the northern side of this property.
On what basis he came in possession?
Well, he gave, by virtue of what happened, this plaintiff filed a suit, my lord, against the third defendant. My lord, in OS number 113.
Now, what is your defense now? Forget about it.
My defense is this. My lord, I have been in possession and enjoyment of this property by virtue of my lord, in respect of 1 acre 37 guntas, which is this present crucial property. By virtue of a judgment and decree passed in a suit filed by the plaintiff against this third defendant, my lord, in OS number 113/96.
No, we are not suit filed by the present plaintiff.
Present plaintiff, she files a suit against the third defendant, that is one Gangadhar.
For what? For what?
My lord, for fair injunction. In respect of my lord, entire 4 acres and odd.
All right. And what happened to that suit?
In that suit, my lord, the trial court held that she is not in possession of northern portion of the social property, and it is in possession of the third defendant. And my lord, it was partly decreed in favor of the plaintiff.
Injunction is
So far
granted,
as
injunction is granted in respect of remaining portion.
remaining for that is southern portion.
All right.
Southern portion. While this judgment and decree has become final and conclusive, because no appeal was filed by this.
All right. All right.
Now, by virtue of that, my lord, I have been in possession. Third defendant, that is the third appellate here, he has been in possession in enjoyment.
Rangappana, you know.
Rangappa Maga. My father was in possession.
You are not the person who has executed relinquishment deed.
Relinquishment deed, no.
You are not a party.
No, I did not execute.
All right. So you are in possession.
I am in possession. And suit is dismissed as against this defendant and portion starts. Don't know really this thing. And again, we have.
Why are you in appeal then?
Yes, our main contention is, my lord, this very suit is, my lord, filed by them, barred by litigation. And there is no relinquishment deed alleged to have been issued.
No, there is no decree against you. How are you in appeal?
My lord, I filed, yes, it's like, why I have come before, not only I am, my lord, other defendants have also filed there.
Other defendants and sister.
Yes, my lord.
Agreement who has
Yes.
executed relinquishment deed.
All together they have filed this.
So you can argue on behalf of the person who has executed relinquishment deed, not on behalf of son of Rangappa or whatever, because there is no decree against it.
Yeah, of course, there is no decree.
You are not a great person.
Yes.
Only you can say that how that relinquishment deed should not be executed or should not be given. Yes.
By that time, I can't contain that because my lord.
You have received entire amount.
Not me. That is this first appellant has received according to them and
The first appellant. First
Yes.
appellant. Who is the second appellant?
second appellant, my lord, is one Kallappa.
Who is he?
By Allah's.
Who is he? Who is he?
Husband of this one.
Husband of the one.
Yes.
So Kallappa has no say.
Yes, my lord.
Kallappa is not aggrieved.
Evidence ಮಾಡಿ.
Kallappa is not aggrieved.
Kallappa, my
Why
lord.
do you made Kallappa as a party? Why Kallappa is made a party?
Party because he has D1 and D2. The husband and D1 and D2 both have received 35,000.
Together.
Husband and wife.
Hmm.
So my, so far as my lord, of course, the challenge to this land my ground is, appellants I have held up in, we are from Andhra. My lord, first on the ground of communication. My lord, according to admittedly, my lord, this relinquishment deed was executed on 7/6/1988.
Hmm.
My lord, suit is filed on 24/6/1988.
Hmm.
My lord, after 11 years of specific performance.
Hmm.
Therefore, my lord, it's clearly barred by law.
Now, what was the time fixed under the agreement?
Under that, no time is fixed.
What time is
No
fixed?
time is fixed.
When did you deny this agreement?
My lord, from the beginning, my lord, we denied.
How do you say that?
Because, my lord.
Where is it established? See, according to you, the first agreement dated 7/6/1988 doesn't fix a time limit for specific performance, for specific performance. Yes. Then you must establish that on a particular date, you have disputed this agreement and that becomes the cause of action for him to file a suit. So what is the date on which this agreement is disputed?
Yes, there was another suit filed by them.
Between sisters, I know.
Between.
Why don't you pay some money to your sister?
Agreement holder, eligible to be the agreement holder.
I'll
And possession, no, without title.
See, ultimately she is your sister. Alva,
I will apply.
Appellant. Why don't you pay some money to her? See, she has paid this, received rupees 35,000 and she has relinquished her share in 1988. Just a second, value of land in 1988 was meager. Now it has risen astronomically. So you are the beneficiary. Why don't you pay some money to your own sister? Third appellant has no. He has enjoyed the possession. He has enjoyed the possession. Let him enjoy, but he has no right over the plan.
Of course, my lord, I am
On
not.
behalf of appellant number 1 and 2, ask your sister to pay some money and put an end to this.
Last time. Because I have no, I can't challenge this document. I am a stranger to it. I
Yes.
admit that. But I continue to be possession.
That you have enjoyed.
Yes. And
Make some payment. Make some payment. See, by referring to some provision of law, delivering a judgment may not satisfy both the parties. Give some amount. The request of learned counsel for the appellant and respondent. 10 days time granted to explore the possibility of settlement. 2 weeks time granted to explore the possibility of settlement. Dismissed matter on 18th. 17th now.
Only in terms of money, my lord.
Whatever. It's up to you. This matter on 17th. And please see that the matter is settled.
we made all endeavor to see this malady.
Convince your client as to where she stands.
Yes.
Serial number 28, Keshav Kumar B.
Also.
Number 29, yeah, Naresh.
Why? Admission. This is for admission. 28 alva. For admission. 29. This is for admission. Admit agide illa. All right, for admission, paper book not required. You argue the matter on admission. The request of learned counsel for the appellant is this matter after 2 weeks. See, this is your appeal. After 6 years, you are not ready for admission. You don't want the matter to be admitted. Awesome. Awesome. For appellant. Why?
Party has engaged senior counsel at Kodar 5.
Awesome. Awesome. I number 1 of 16 for production of additional document shall be heard along with the main appeal. This matter after 2 weeks.
Senior counsel.
This matter on 17th.
Serial number 34, I am for the appellant. This matter, I have argued the matter on the last date of hearing. My friend produced an agreement of sale. He wants to produce the agreement of sale, original agreement of sale. This is regarding two friends have
Understood.
entered into.
Understood.
Yes, ma'am.
Yes. What is your say on that agreement?
No, the appellant is denying the signature.
All right.
But I am not served with any application for production of additional document.
Ready there. Current counsel for the respondent submits that he is filing an application for production of additional document. Today in the register. This is along with that application on November. There is one judgment, recent judgment of the Supreme Court. Narayanamma Antina Bharatana. Narayanamma, Narayani Devi. That says if the agreement is barred under any law, that agreement can't be enforced. Land Reforms Act Supreme Court. There is one Supreme Court judgment. That probably come in the way.
I will verify it, ma'am.
Not settled. Counsel for the respondent submits that the matter is likely to be settled. This matter on 14th November. Yes.
Not possible. Others are not agreeable, he said. Parties also.
Yes.
Proposal we have given is not agreeable to them. Let them give one more proposal. No, that's what I spoke to him in the morning also, even before coming to the court. He says his brothers are not agreeable, sir. It's not fun.
Yes.
So I could not do much. He's presented.
What was this one?
Not used for declaration that the sale is executed by not binding on him and cancel the sale. The trial court declared this would.
What the first appellate court did?
The appellate court has reversed the finding.
On what basis?
It is that the sale deed is registered. They admit the signature. Therefore, cannot be said that the sale deed is not.
The very person who executed the sale deed has filed the suit.
Yes, sir.
On what basis?
On the basis that there were two proceedings before the court below, for the same court, and that the second defendant's husband was the employee of the court. He may not use us to sign some documents, saying that the proceedings, not these earlier proceedings, would get disposed of in their favor. And also, may not, there was a mortgage deed, simple mortgage deed earlier to this, in favor of the father of this first defendant. That may not, we got it discharged under the Karnataka Debt Release Act. Tahsildar passed an order discharging the debt. Out of that vengeance, may not, he got two signatures from the plaintiff, and misused his position in the court, and got those documents signed by the plaintiffs. Was our case before the court.
How the plaintiff went to the office of the sub-registrar?
Plaintiff did not go to the office of the registrar.
Signature, thumb impression on this,
Only on the first page.
thumb impression on the sale deed.
Yes, that is only on the first page, not he has signed. The other portions of the thumb impressions, he says, not, they are not used. Because he has not gone to the sub-registrar's office.
How that is sought to be proved?
That not negative, not I cannot prove.
No, if you say that this is not your thumb impression, who has to take steps?
Those documents not now. I understand. The thumb impression was not mine. Not we have not gone to the sub-registrar's office. It's our case, and probably that document, thumb impression, was to be sent to the for comparison. That has not been done.
Then
Then the evidence of the.
so you admit the thumb impression on the first page.
Yes.
Thumb impression on remaining two pages disputed.
And also on the back side of the page when the registration is done.
Where is the evidence to that effect?
Evidence to that effect is
That you are disputing the thumb impression on remaining two pages.
I will file a copy of the evidence.
The thumb impression on remaining two pages disputed. Thumb impressions on sale deed.
In pleading, they are not disputing thumb impression and all that. On the other hand, they contend that the signature has been obtained on the blank paper, and that has been utilized for a registration of the sale.
All right. The process of registration, in addition to the signature, the parties are also required to put the thumb impression.
That is there. That is not disputed. In the sale deed, it is there.
No, whether that person, plaintiff,
He has not.
in the normal course, he puts the thumb impression or the signature.
He is only talking about the signature that it is obtained on the blank paper. He is not talking about thumb impression at all,
No,
either in the pleading or the.
What you are saying is he knows how to sign.
Yes.
He knows how to sign.
Yes.
And he has put the signature.
Yes.
So signature is admitted.
Yes.
What about the thumb impression on the sale deed?
Thumb impression is also on the sale deed. Also, they say they have taken thumb impression and the signature on the blank paper. That's all they say. So therefore, insofar as the thumb impression and
is also
signature
admitted. Even thumb impression is admitted.
admitted. That is also.
So where do you say that the second and third page thumb impressions are disputed? Who is respondent number 2? Allah, how is related to plaintiff? How are you connected to this property?
His wife is the
You say that you are in possession of the property as a mortgagee.
discharge. His wife is respondent number one.
All right, no, let us hear him later. You show me that you have disputed the signature or thumb impression on the sale deed on all the pages. Where do you say so?
Client government seal, there is no cause of action at all. Because according to them, the signature is obtained on the blank paper, which a promise that he will manipulate the, he will utilize that paper for winning the case which is pending before the court. In fact, the case was disposed of even earlier to this age. And there is no pleading when the signature was obtained, when the misrepresentation was made, under what circumstances, regarding fraud and misrepresentation as required under order 6, there is absolutely no pleading. Kindly see the plaint itself. Para 6. Second. But the evidence copy is not readable, but I just wanted.
You are the appellant.
The appellant. The paper book was filed, not the records were destroyed. We did not have the copy. The mortgage was I mean, that second different
The
mortgage.
request of for the appellant. This is not on Monday, na? Tuesday is the last chance. No adjournment.
Tuesday is the holiday.
Wednesday.
November 1st. Wednesday, November 1st.
Further reading and money there. For further reading. For further reading.
Number 40, same resolution.
Just a second. Hindu ಮತ್ತೆ Arvind Jayaprakash. In one case, issue was framed. Fix the date for appearance. 21st of November ಏನೋ ಇದೆ. Remember, you will get that in the copy. Copy apply ಮಾಡಿ. Just inform Jayaprakash also. What is this? Pass out. Yes. I will hear them. Yes. ನಿಂದಾಗಿದೆಯಾ?
ಏನಾಗಿದೆ in the case where suit is initially by injunction, subsequently it was converted to admittedly the appellant is the owner of this. And when the suit is filed, the defense taken by the other side is that one is adverse possession. That defense of adverse possession has been held against. The other defense is that he also contended there is an agreement of sale by my client, that is the original plaintiff, in his favor. Admittedly, my lord, the agreement of sale has not been enforced in a manner known. Trial court, considering all these aspects, has given a finding that the agreement has not been enforced, and I am entitled for protection by following through the division bench rulings of this court. Now, my lord, the first appellate court has reversed that finding, mainly on the ground that the suit is filed within 15 years from the date of date of the grant of this acknowledged, not the grant order. So in that view of the matter, suit could not have been done. I have filed a suit for permission. It is nothing to do with this agreement of sale as such. And even after filing of this, They have not filed any suit for specific performance within the time frame that is. So in that background, I have challenged the judgment of the court.
Any judgments in support of your case?
One is ILR 1994 Karnataka, page 1665. Another one is ILR 1992 Karnataka, page 429. 95 Karnataka. Another one is ILR 1992 Karnataka. 429. Last time court report.
ALR 92, 429. Which paragraph? Yes.
But the note itself says limitation for 3 years from the date of the knowledge of the notice of denial of the agreement, whether the date fixed in the agreement expired or not. Suit seeking for possession from the defendant placed in possession repudiation of the agreement of sale. That also almost right here, repudiation of agreement of sale. And defendant has to exercise the right by filing a suit within 3 years from the date of the service of the suit. That is what ILR 1992 says. The relevant paragraph is.
In your print, you have denied the agreement. In your print, you have denied.
We have not even referred to the agreement.
In the written statement, you have referred to the agreement.
They have referred.
Have you filed rejoinder?
No, I have not filed any rejoinder because what has happened is there is no counterclaim in the written statement. And question of filing a rejoinder under
In your evidence,
our evidence will not.
have you denied the agreement? You have denied.
Now, what has happened in this case, the same thing is evidence and both oral and documentary evidence is not available before the court because
You don't have the
matter was
copies?
decided by the first appellate court.
You don't have the copies?
I don't even have I have the copies of some exhibits, but not the evidence copy.
All right. This is your contention.
That is my contention.
You are the owner. He is only an agreement holder. He has to endure possession. Yes. Show the reasoning of the first appellate court.
Kindly go to. Kindly, the relevant portion is from para 20.
Para?
20 of the judgment. First appellate court.
Yes.
The lower court, while relying upon the entries made in the revenue records through the presumption under the Section 133 of the Karnataka Land Use Act, that the plaintiff was in lawful possession of this property, but not only granted injunction, also granted possession of this land from the defendant, and it is an error committed by the lower court. Whereas the presumption arising under Section 133 of the Karnataka Land Use Act. So exhibit even the agreement of sale, say it is in favor of the defendant by this is plaintiff under its handwriting. Has limited the entries made in the for a rights. Even PW2, the plaintiff's witness has admitted about the execution of exhibit in favor of the deceased defendant and delivery of portion of this person to the deceased defendant.
You have received entire consideration amount?
That's what the agreement says. Agreement says that.
The sale deed was not executed because of the stipulation of 15 years.
Yes, even subsequent what has happened is 15 years, when does it expire is the question. Whether it expires from the date of the grant, which is in 1970. If that is the thing as on the day when I filed the suit for possession, that 15 years had already expired. If they take into account 78, that is the day on the Sagwadi issue, then as on the day when I filed the suit, 15 years had not lapsed.
15 years alienation, non-alienation clause, where it is found?
According to
the grant order in Sagolichi.
Those two documents are not available. But in the mutation register extract, which is the I may be permitted to file copies of these documents also. That would help. Because I have only few copies of the exhibits. In exhibit P3,
Grant under which provision of law? Land grant rules?
Land grant rules. And what it says is, in this invitation they used to extract. It refers to this, this is stated in that. in so and so. Enguvarin, Tasildar Bhadravati Varinda, LNTCR 195 or 7273. Tariku Yelu Muri Apatmura Pakara. IC number Muru bar 1977-78 Pakara. Telecast and Vir Manduragide. 15 ವರ್ಷದವರೆಗೆ ಪರಬಾರೆ ಮಾಡಕೊಡಬೇಕಾದ ಶರತ್ತು ಕೊಡಪಟ್ಟಿದೆ.
That is 1973. That is 1973.
73 is the date of grant.
Yes.
Now, apart from the my submission to this matter.
So 15 years.
73 or 77.
No, 15 years have to be reckoned from 1973 from rate of grant.
Yes. That is 70, it comes to by 88. I filed the suit for possession in 1 minute. Suit is filed.
So when this agreement was executed, there was a prohibition.
There was a prohibition. But what has happened is, this suit is filed in 1990. After the expiry of 15 years. Even after the filing of the suit, even assuming for a moment 78 is the date on which 15 years period would commence. Within the time prescribed under law, no suit for possession.
Understood.
So my submission would be by following the element of our own would have had that the very filing of the suit for possession amounts to repudiation of the agreement.
There is one more angle you are not addressing.
Yes.
If alienation is prohibited within 15 years, could you have transferred the possession within 15 years? Could you have transferred the possession within 15 years?
What is prohibited? Because we don't have that particular document. What is prohibited is alienation, number one. So I am only answering a hypothetical question. We have not admitted that agreement is another aspect of it.
No. Suit for possession.
I have filed a suit for possession.
So that means, just a second. Are you saying that he is a trespasser?
Yes, what happened is this.
The plain government is a trespasser?
I am answering that. Question. In the plaint, when we sought for amendment, we did not incorporate those particular aspects under which we are seeking for possession. In the plaint, it is not there. Unfortunately, what has happened is an application for amendment was filed. In the affidavit accompanying the application, there are averments to the effect that during the pendency of the suit, he has been dispossessed.
So we got a copy of that application?
Yes, sir. I have the copy of the application. That is what has happened. Unfortunately, what had happened is, while preparing the application for amendment, what averment should have been there related to
what is the averment in the agreement for sale?
Agreement for sale without the says possession is there.
This is delivery.
But we have not really admitted that document.
All right.
Otherwise also.
Assuming that the government is true.
Yes.
Then you have transferred the possession during non-alienation period. What is the consequence of that?
The consequence would be, that doesn't amount to, even assuming for a moment, there are two issues here. Number one, whether the restraint of alienation does it prevent from transferring the possession, whether that can be interpreted or not is one aspect of it. Second thing is, assuming for a moment that amounts to a violation of that particular condition, the cancellation of the grant is the only thing that can happen. That is within the purview of the revenue authorities. That has not happened. But here is a case where we don't admit that agreement. And
you are not disputed either.
We have not disputed this in the. I am in a disadvantageous situation because I really don't have the copy of the evidence recorded by the court. How the evidence has been rendered, what was the examination report, but ultimately on admitted facts. Yes, it is their case that there is an agreement of sale. Going by their case, I have filed a suit for possession.
Understood.
And he is not the owner of the property. When I file a suit based on title, well, the only defense that he can have is
possession.
That has been negative. So in that background, from looking from any point of view, my respectful submission would be that a person in possession pursuant to section 53A, he has to, that's what the other ruling which I have given without says. He must, if a suit is not filed, but to enforce the agreement, then he cannot resist a suit for possession filed by the true.
Yes. All right. Yes. Your defense is only under section 53A.
This matter, my submission is this. Now certain legal conflict have been resolved as of now. Firstly, my lord, incorporation of non-alienation in a grant. It would not come in the way for enforcing the agreement even before the 15 years as held by the division bench of our High Court.
Yes, understood.
What is prohibited is execution of a registered sale deed is only prohibited.
Yes,
Transaction would be completed only on execution of the registered sale.
all right.
Therefore, suit could be filed for specific performance even before expiry of the 15 years. This is one issue is settled. Second issue which is settled is merely because I failed to file a suit for specific performance. It does not take away my right to resist the suit filed by the other side so far as possession is concerned. On any other ground, including limitation also this is also my lord. And thirdly, my lord, section 53 capital A is totally an exception to any other provisions. It stands on its independent foot. Because this question was referred to the larger bench by our High Court in 1998 and it was resolved. May I take your lordship's judgment of the full bench of our Honorable High Court, reported in Minute ILR 1998, the Karnataka Law Journal, page 73.
What is the judgment of the apex court on this point?
And the apex court is not identical. That was 2002, Supreme Court page 960. It was the case where 53A was specially examined in the background of the reports and other history for the purpose of incorporation of section 53A into the Transfer of Property Act. 53A was incorporated in Transfer of Property Act by the amendment of 1929. It's a pre-independent amendment. Lord, may kindly see, my lord, how this was examined by the. But your lordship may kindly go to head note B and head note C for a moment. In our High Court judgment, larger bench judgment.
Yes.
The Karnataka High Court rules want, so it is with reference to reference is concerned. Then there are section 53 at head note C. Part performance doctrine, though based on equity, doctrine follows part of substantive law, granting transferee right to retain possession on ground of part of performance. Object of provision entails to left bar of limitation in protecting possession on basis of agreement to transfer. Provision in effect relaxes rigor to act and also registration act. It is exception to the provision which requires contract to be registered. Wherein a written contract to say transferee has in part performance of the contract taken possession continues to be in possession, has also performed his part of the contract paying full amount consideration. Transferor is stopped from seeking recovery of the possession on the ground that transfer was not effected under the registered deed, that transferee had failed to bring the suit for specific performance of contract within period of limitation prescribed therefore in the Limitation Act. Held section 53 capital A creates a statutory right in favor of the transferee, though the inspiration for incorporating the same might have been derived from the English equitable doctrine of part performance. But it is now more than a settled law that in India, right of a transferee to defend his possession over a evil property acquired pursuant to a contract, subject to fulfillment of statutory conditions contained in the said section, is a statutory in nature, cannot be whistled out in the equitable concept of laches or implied limitation. Notwithstanding the fact, well, it is very important, notwithstanding the fact that a transferee in possession pursuant to a contract of the sale fails to file a suit for specific purpose within the prescribed period of limitation, still in law, contract remains valid, operative entitling him to exert his right to retain the possession over the property in the act by way of defense in a suit brought against him by the transfer or recovery of possession. Law of limitation does not apply to a defense cited under section 53 capital A of the Act, since section does not provide for any limitation expiry whereof defense contemplated in section will be lost, will extinguish. Therefore, the right of the transferee to defend possession envisages under the approach statutory in nature it has not been subject to any limitation, may kindly make a note. Then either expressed or implied. In that view of the matter, division decision of this court cannot be said to have laid down a good law and accordingly overruled on the legal and inward. Not various other aspects have been considered. Then may kindly go to Supreme Court judgment relevant. 2002 SC 960. There are may request losses to may kindly come to the right side column, commencing from the special committee's report. Could your losses?
Page number?
Page 960. Head note to continuation. But why may kindly go to beginning? A perusal of section 53 capital A, earlier paragraph, immediately after head note B. Could your losses below? Yes. 53A shows that does not forbid a defendant transferring from taking a plea in his defense to protect his possession over the suit property obtained in part performance of a contract, even though period of limitations for bringing a suit for specific performance has expired. It also does not expressly provide that the defendant possession over the suit property taken in part performance of the contract, if the period of limitation to bring the suit for specific performance has expired. In the absence of such provision, court has to interpret the provision of section 53A in a scientific manner. It means to look into the legislative history and structure of the provisions of 53 capital A. The special committee's report, which is reflected in the aims and object of amending Act 1929, shows that one of the purposes enacting section 53A was to provide protection to a transferee who in part performance of the contract had taken possession of the property, even if the limitation is bring a suit for specific performance has expired. In that view of the matter, 53A is required to be interpreted in the light of the recommendation of the special committee's report and yes, object contained in amending Act.
Just a second, read para number 14.
Para 14. But there are certain conditions which are required to be fulfilled. If a transferee wants to defend or protect his possession under section 53A of the Act, there must be a contract. Contract must be in writing. Writing must be in such a form. Transferee must part performance of take possession of the property. Must have done something in furtherance to that. Transferee must have performed willing access. But absolutely there are no records whether it is there or not. It is nobody's case also. No, there are no records at all.
No, agreement is there.
Agreement is there. Agreement under which the entire sale consideration passed on to other side. I put in possession. That's an end of the agreement. Then they filed a suit. They said we are in possession. Please protect my possession. It was their case before the trial court. Trial court. My defense is I am an agreement holder.
Just a second. Read para number 14. Takes care of defendant's interest.
I understand, but there are, and I mean.
Which condition is not fulfilled? There are 6 conditions.
Yes, yes.
Which condition is not fulfilled?
The question would be this. The transferee must in part performance of the contract, apart from that, transferee must have done something in furtherance of the contract.
Yes, what is required to do? In this
After
case, so in this case, he has paid the entire consideration amount.
No, after the agreement of.
No, he is in possession. What is required to do? What is required to do under the agreement?
I am concerned. I have not admitted that document.
I am not disputed.
I could not have disputed it because when I know as a plaintiff.
See, you file a suit for possession in respect of a property based on.
I don't recognize that.
All right. He files written statement.
Yes.
You are not responded to that written statement while in jointer.
That's what I'm submitting. Normally, as you lordships are aware, under ordinary only when a counter claim has been put by the defendant, I may have to file a rejoinder.
All right. Now come to para number 14. Come to para number 14 again. Read condition number 1. There must be a contract to transfer for consideration of any immovable property. Now this is just a second. I haven't gone through the agreement now. Agreement is marked, right? Agreement is marked. So there is a contract. Just a second. Contract must be in writing signed by the transferor or by someone on his behalf. There is a signature. Third thing, the writing must be in such words from which the terms necessary to constitute the transfer can be ascertained. there must be payment of consideration amount
That's correct.
and delivery of possession. Next thing. Transferee must be in part of the contract, take possession of the property or any part thereof. Transferee must have done some act in furtherance of the contract.
What I am saying is,
It's all right. In
What
further-
is the
no, just a second. In furtherance of the contract means you must read the terms of the contract. What does it contemplate? No, what does it contemplate?
maybe one request. And then senior counsel were relied upon the judgments. But of course, I have gone through them. Prima facie, the judgments appear to be in their favor. I may be given 2 days time to examine this issue and respond.
Now come to point number 5.
Yes,
The transferee must have done some act in furtherance of
that's what I am
contract.
submitting.
So you have to read the contract.
Yes. I'm
What-
saying,
What
what
the
is
terms and conditions contemplate
Yes,
for the transferee to
correct.
that.
But something in furtherance means, what I am saying is, when there is, even the revenue records, your lordship may kindly see, they continued in my name under section 133 of the Karnataka Land.
You are the owner.
Correct.
It will continue in your name. You are the
What
owner.
happens in the-
You never claim to be the owner.
At that particular point of time, in column number 12 of the revenue records, the person in possession's name could have been shown, if at all, if there were to be an agreement of sale.
That was in there 1977.
77.
No, that is not permissible.
Or 74 onwards, it was not.
It's not permissible.
But at the same time, there is no material whatsoever to indicate that he has made any efforts to call upon the plaintiff to execute the sale deed, even after the expiry of the period of non-alienation. Is it not something
Mr.
which is
Rajgopal.
required to be done in furtherance of the contract?
Come to condition number 6.
Yes.
Condition number 6.
Yes.
The transferee must have performed or be willing to perform his part of the contract.
Whether this question would arise, what required to perform?
So that's what I'm asking you.
Yes.
What are the terms and conditions of the contract?
But an agreement is there, only thing is
What
I
are the
have,
terms? Give me the
I have got the agreement,
Give me the copy.
this is the agreement, it has requires my lord, typed copy to be made available. Anyhow, it is our, we have an obligation to take a burden to read, why we have to transfer to your lordship.
No.
Therefore, we will get it typed, we will furnish it to your lordship. Make it easy for your lordship, they are taking view of your lordship's eyesight.
It's not part of the trial court record.
But trial court records
What
is
has
not there.
happened is,
It is
oral
destroyed.
evidence and document evidence is not available.
Look at the-
ಎರಡು ಇಲ್ಲ. First appellate court ಅಲ್ಲಿ matter.
There is some agreement. Elena, is there?
Agreement ಇದೆಯಲ್ಲ.
ಅದೇನು agreement ಇದೆಯಾ? That's the finding of the first appellate court.
Exhibit D1.
Yes.
It is there.
Oral and document evidence is not there.
11/7/1977 agreement. 11th July.
7? Yes. This is
11/7/1977.
agreement is there. Exhibit D1.
There are one more surprising factor is
Why do you say that the records are not available? Records are here.
That is the finding.
evidence ಇಲ್ಲ.
Evidence ಇದೆಯಾ ಸ್ವಾಮಿ?
ಇಲ್ಲ. Deposition ಇಲ್ಲ, evidence
Only
ಇಲ್ಲ.
this document is available. Exhibit D1.
That's what I am submitting. First appellate court said has given a categorical finding.
No, relevant document is available.
ನಾನು ಒಂದು ಕೆಲಸ ಮಾಡ್ತೇನೆ, as the registrar has said, we will also get this document typed. Because what Xerox copy I do have.
ಅಲ್ಲ ನಾನೊಂದು ಹೇಳೋದಾದ್ರೆ anyhow a serious question is required to be addressed. So lordship formulate a substantial question of admission against the.
This is final hearing. Final hearing. So we have addressed your argument on final hearing.
Then I look into the substantial.
On a lighter note, you can revise your piece.
It is right. May kindly have it on Tuesday, because I will also examine whether subsequent to 2002, are there any other.
To hear further, is this matter on Tuesday? Just go through the latest judgment.
Not
on
Tuesday,
Wednesday.
Wednesday.
Just go through the latest judgment on section 53A. And just try to find out as whether he is required to do something under this agreement. Exhibit D1.
Whether calling upon him to,
Give a typed copy to him in advance.
whether
Could
calling
it be on
upon.
14th May?
Put it later.
ಅಯ್ಯೋ Wednesday is the second and third. Fourth ಆಗ್ಬೋದಾ?
Fourth, all right.
Fourth.
Fourth.
ಏನೇನೋ ತಾಪತ್ರೆ.
Give typed copy to him in advance. Typed copy of this agreement.
Very well.
This is there. You can go through the file now.
I have the copy of the agreement. That is the only document available. I have the copy.
Also explore the possibility of settlement, assuming that you succeed.
Yes, I will try.
No, you will not have a sale deed. unless he cooperates. Probably you may have to file one more suit.
And whether he can file it now is another aspect.
Yes, those things.
Yeah, according to that larger bench judgment, only for a namesake, I record to file a suit or I should have a registered instrument.
Assuming that,
But the-
no, assuming that you are going to file a fresh suit.
That's
It will
the
take-
reason,
no,
my lord.
it will take its own time.
That's the reason Supreme Court said, section 53 capital A stands in a different footing rather than all other restrictions.
That is understood, but nobody will accept that you are the owner.
Of course,
That is a problem, practical problem.
and also I
So
am
think
not welcoming.
think from practical perspective, try to offer him something valuable. He may agree to sell the property.
I will also.
Then I think
I will also.
court would be the very short span to all, because my client is at Shumaga, their client also at Shumaga. We should get
Both
them
no.
and.
Both are at phone calls away.
We'll try. We'll try to contact them.
Very well. No issues. Let's say. There is no hopes of revising.
Sorry? No, it is left to you. It is left to you. What do you want to do?
That is other easement.
Yes.
Pathway,
Yes.
defendants appeal, both the courts have had litigation.
Both the courts have held that there is a easement of way.
Not,
Commission report says that suit road is in existence.
road is the alternative road was there.
Was
Now
there.
it is up. The question arises whether the present way is absolutely necessity. Under that principle it comes or not is the question. Maybe it may be convenient for him. Because why he has stopped that is also not committee.
All right. When the commissioner visited this spot, there was only one way. When the commissioner visited this spot,
Yes,
there was
shown
only one.
the alternative way also, my lord.
All right. The question is whether that alternative road was in existence as on the date of this.
Maybe, my lord, that may be one.
Where is the evidence? How do you say that alternative road was in existence as on the date of this? By referring to the commissioner's report, probably you are in a position to say at one point of time, there was one more road. But where is the documentation?
That has come in the commission report also.
Yes. So
Yes,
so where is the evidence to show that as on the date of this suit, there was one more way available to the plaintiff?
Maybe to that extent, my lord,
There is no evidence.
there is no lacking, my lord, but the question is, my lord, whether he can, when the alternative road is.
Alternative road is not established.
No, it
Alternative
is
road.
established, but on that,
As
as
on the
the
date of
lordship
this.
put it, my lord, on the date of the, that is, because alternative road is shown in the
Road or pathway?
pathway. No, my lord.
What is the width?
Anya marga
No,
virudilla.
what is the width?
It's about 3 feet. 3.5.
Length?
3 feet.
Now, in which question the commissioner says Anya Marga Virodhina?
Kindly see the report.
Yes.
Exhibit
Question.
P7.
Yes, question.
ಪ್ರತಿವಾದಿಯವರಿಗೆ ಸೇರಿದ
Question number. 6.
6.
Yes.
ಆಯುಕ್ತರು ಪರಿಶೀಲಿಸಿದಂತೆ ಪ್ರತಿವಾದಿಯವರಿಗೆ ವಾದಿರ 35/24 ಬಿ ಯಲ್ಲಿ ಹಾದು ಹೋದ ನಡೆ ಕಂಟೆ ಅಕ್ಷಯ ಹೊರತು ಪಡಿಸಿ ಅನ್ಯ ಮಾರ್ಗವಿರುವುದಿಲ್ಲ.
Yes.
Next para,
Yes.
8 and 9. ಪ್ರತಿವಾದಿ ತೋರಿಸುವ ಹಳೆ ನಡಕಂಟ ಹೊಸದಾಗಿ ಕಟ್ಟಿದ ಮನೆ ತಾಯ್ಕೊಂಡಿದ್ದು ಪಶ್ಚಿಮದಲ್ಲಿ ಸಕಲ ಕಲ್ಲು ಹಾಸುತ್ತಾರೆ ಹಾಗೂ ದಕ್ಷಿಣದಲ್ಲಿ ಕಡಪ ಕಲ್ಲು ಹಾಕಿದ ನಂತರ ಪ್ರತಿವಾದಿಗಳು ದಕ್ಷಿಣದಲ್ಲಿ ಈಗ ಉಪಯೋಗಿಸುತ್ತಿರುವ ನಡೆದಾರೆ ಬದಲಿ ವ್ಯವಸ್ಥೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ.
Just because he has changed a pathway, my lord, defendant can't be penalized for.
Just a second. ಪ್ರತಿವಾದಿಯರು ತೋರಿಸಿರುವ ನಡೆಕಂಟ that you have suggested alternative way. That means ಹೊಸದಾಗಿ ಕಟ್ಟಿರುವ ಮನೆಗೆ.
ಪ್ರತಿವಾದಿ my lord, in that suit,
just a second.
that suit I am the plaintiff. This is in the other suit. Yes, because the commission report was
All right.
in other suit.
Commissioner is examined.
Yes, please. Commissioner is examined PW3.
All right. This is the report in the old case.
Yes.
In the old case, the present plaintiff was the defendant.
How? Please.
ಪ್ರತಿವಾದಿಯರು ತೋರಿಸಿರುವ ಹಳೆ ಕಂಠ ಹೊಸದಾಗಿ ಕಟ್ಟಿರುವ ಮನೆಗೆ means whose house? Who has built a new house?
ಅವರು ಕಟ್ಟಿದ್ರು.
ಪಶ್ಚಿಮ ಮತ್ತು ದಕ್ಷಿಣ ದಿಕ್ಕಿನಲ್ಲಿ ತಾಗಿಕೊಂಡಿದ್ದು.
ಪಶ್ಚಿಮದಲ್ಲಿ 4 ಲಿಂಕ್ ಆಗದ ಕಡಪ ಕಲ್ಲು ಹಾಸಿರುತ್ತಾರೆ ಹಾಗೂ ದಕ್ಷಿಣದಲ್ಲಿ ಕಡಪ ಕಲ್ಲು ಹಾಕಿಸಿದ ನಂತರ ಪ್ರತಿವಾದಿಯರು ದಕ್ಷಿಣದಲ್ಲಿ ಈಗ ಉಪಯೋಗಿಸುತ್ತಿರುವ ನಡೆದಾರಿ ನಕ್ಷೆಯು ಬದಲಿ ವ್ಯವಸ್ಥೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಅದು ಆ ನಕ್ಷೆ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ.
Just a second. So defendant has made an alternative way. You are the defendant in that suit.
I am plaintiff.
ಆ ಕೇಸಲ್ಲಿ plaintiff ನೀವು?
ಪ್ರತಿವಾದಿ ಅವರು ಅಲ್ಲಿ.
ಆ ಕೇಸ್ನಲ್ಲ?
I have filed a suit for injunction. There the observation was you will have to file a
complaint. ASKLMNRY ಎಲ್ಲಿ ಬರುತ್ತೆ ಅದು?
ಅಲ್ಲಿ next sketch ಇದೆ.
Yes.
Sketch ಅಲ್ಲಿ
yes, I got A.
ಅಲ್ಲಿ ಕೆಳಗೆ ಸ್ವಲ್ಪ ಕೆಳಗೆ ಆದ್ರೆ ಅಲ್ಲಿ
Yes,
M ಅಂತ ಕಾಣ್ತದೆ. ಎಸ್ ಇದೆ.
Yes ಬರ್ತದೆ.
ಎಸ್ ಬರ್ತದೆ. ಹಾಗೆ
ಕೆ ಕಾಣ್ತಾ ಇಲ್ಲ. KLMNRY ಕಾಣ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ ಅಲ್ಲಿ ಇದೆ ಕೆಳಗೆ 43 ಅಂತ ಒಂದು ಬರ್ದಿದೆ. ಅದರ ಕೆಳಗೆ
ಇಲ್ಲ. ಕಾಣ್ತಾ ಇಲ್ಲ.
6 ಅಂತ ಇರೋದು ಲೆಫ್ಟ್ ಸೈಡ್ ಇದೆ. ಆ 86 ಅಂತ ಲೆಫ್ಟ್ ಸೈಡ್ ಗೆ R is also prepared casual wear. No, somewhat because no. This in the cross examination it has come.
Also yes,
Can I mark it in pencil?
ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಮುಂದೆ ಬಂದು ತೋರಿಸಿದ್ರು. ಮುಂದೆ ಬಂದು show to the court officer. AS I can make out. And KLMNRY. You got all the points? In that sketch, much of the space is wasted to show the area where there is no controversy. No, there is no controversy at all. As the paper could have been used in a better fashion. It should have enlarged the controversial portion. You have cross-examined the commissioner? You have cross-examined. Even now the dispute is subsisting between the parties? Even now? Or they have settled the dispute? Afternoon there is a division bench sitting. See, A, I have noticed. This is A. This is S. On the top. A is there. Yes. A, yes. Yes. What about others? Where do you get K? K for Karnataka. Where do you get? How do you say that it's K? That is G. The letter G is written there. It's not K.
Small K ಅಂತ ಇದೆ.
Yes.
ಹೌದು.
Yes.
A ಪಕ್ಕ ಅದು ಕಲರ್ಡ್ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಕಾಣೋದಿಲ್ಲ.
Yes, got it.
Yes.
So that is ASK. Then
LM N ಮಾರ್ಕ್ ಮಾಡಿದ್ದೇನೆ.
L.
M N. If that is read along with the report, then R is the road.
Just a second. ASK
L.
AL N.
N.
Before N, you should get M.
M ಇದೆ. I marked it with pencil.
Yes. Yes.
Yes. All this.
So which is your land? Survey number 24A.
Yes. That 24.
24A is your line. The 24A is your line.
No, 34 or 24A is my land.
Yes, understood.
That is plaintiff's.
24B is defendant's land.
Yes. to reach the southernmost portion of it,
Yes.
that is R.
Yes.
R to D is the road.
Yes.
There is no other
All right.
passage.
So according to this sketch, sir, according to this sketch, alternative road is not shown.
Alternative road, my lord, GHIJ in the index, my lord, it has GHIJ. ಈ ಹಿಂದೆ ಕಾಲುದಾರಿಯಾಗಿತ್ತು ಎಂದು ಹೇಳುವುದು. That is what he said. He himself.
No, then just a second. Even GHIJ is passing through survey number 24B. That is your land.
Yes. Even my lord, in the.
No, GH, if that is accepted, that is also part of your land. It is passing through your land. See, this horizontal line you are referring, GHIJ. If you say that he had access to this portion, then how can he come to this portion without traversing this portion?
My lord, had objected for commission report also. This is the problem, my lord, with even thereafter, my lord, para 14 of the report mechanism.
Now you show me the alternative way, according to you, which is the alternative.
The whole finding was based on the commission report, where
In a case like this, it's like that.
it has not been, but they refer, my
Now you
lord.
admit at one point of time, your party and his party jointly own this property. Alva?
Yes, yes.
Heard. The donate advocate.
One.
Yes.
Subject to your lordship, my lord, my job. In fact, my lord, your lordship, just now ask, my lord, whether commission has been
Cross-examined.
there, my lord, 11th para, I will just read.
Yes. PW? 2 na?
P3.
ಇಲ್ಲ PW3 evidence ಇಲ್ಲ. ನಿಮ್ದಾ? Is it yours?
Record.
All right. Yes.
P3, my lord.
Yes. ಆ ಪ್ರಕರಣದಲ್ಲಿರುವ ಪ್ರತಿವಾದಿಯರು ದಕ್ಷಿಣದಲ್ಲಿರುವ ಕಡಪದ ಮೇಲೆ
ಕಡಪದ ಮೇಲೆ
ಮೊದಲು ನಾನು
ಮೊದಲು
ದಾರಿಯಾಗಿ ಉಪಯೋಗಿಸಿದ್ದೆ, ಈಗ ಬೇರೆ ದಾರಿ ಮಾಡಿಕೊಂಡಿದ್ದೀನಿ ನನ್ನ ಮುಂದೆ.
ಪ್ರತಿವಾದಿ, that is plaintiff, my lord, in this case. ಸ್ಥಳ ಪರಿಶೀಲನೆ ಸಮಯದಲ್ಲಿ ಹೇಳಿರುತ್ತಾರೆ, ದಕ್ಷಿಣದಲ್ಲಿರುವ ಕಡಪದ ಕಲ್ಲುಗಳ ಮೇಲೆ ನಡೆದಾರಿ ಇರುವುದು ಯಾವುದೇ ಗುರುವು ನನಗೆ ಕಂಡು ಬರಲಿಲ್ಲ. ಆದರೆ ಪಶ್ಚಿಮದ ಕಡಪದ ಕಲ್ಲುಗಳ ಮೇಲೆ ನಡೆದಾಡುವ ಗುರು ಕಂಡು ಬರುತ್ತದೆ. ಸದರಿ ಗುರು ಈತ ಬಗ್ಗೆ ನನ್ನ ವರದಿಯಲ್ಲಿ ಕಾಣಿಸಿರಲಿಲ್ಲ. ನನ್ನ ನೆನಪಿನ ಶಕ್ತಿ ಆಧಾರದ ಮೇಲೆ ಸದರಿ ಪಶ್ಚಿಮದ ಬದಿಯಲ್ಲಿ ನಡೆದಾಡುವ ಬಗ್ಗೆ ಗುರು ಇದ್ದ ಬಗ್ಗೆ ಹೇಳುತ್ತಿದ್ದೇನೆ. ಆ ನಕ್ಷೆಯಲ್ಲಿ ನನ್ನ ವರದಿಯಲ್ಲಿ ಕಾಣಿಸಿದ ಯಾವುದೇ ತೊಂದರೆ ಇರಲಿಲ್ಲ. ಕುರುಹು ಎಂದರೆ ನನ್ನ ಪ್ರಕಾರ ಚಪ್ಪಲಿಗಳನ್ನು ಹಾಕಿಕೊಂಡು ನಡೆದಾಡಿದ ಕುರುಹು. ಕಡಪದ ಕಲ್ಲುಗಳ ನಡೆದಾಡುವ ಕುರುಹುಗಳು ಶಾಶ್ವತವಾಗಿ ಎಂದರೆ ಸರಿ. ಸದರಿ ಕುರುಹು ಇದ್ದ ಕಡಪದ ಕಲ್ಲುಗಳ ಪಶ್ಚಿಮದಲ್ಲಿ ಉತ್ತರ ದಕ್ಷಿಣವಾಗಿರುತ್ತದೆ.
Yes.
There, my lord, he says alternative road was there. So due to his lapse, my lord, should not be penalized. Even, my lord, I will just read the.
No, you refer to this sketch and tell us from the records where the alternative road exists.
Because he himself said, my lord,
No, he raised some Kadapa, Pashchima Dipo, this thing we can't understand. You tell us from the sketch where the alternative road existed.
admittedly, he has not mentioned it, my lord.
No. All right. Yes, let us assume that he has not mentioned. Now you point out from which point it went and to which point it passed through and from to which point it reached. You show the contours. So location of survey number 35/24A on the northern side is not disputed. 24B lies on the southern side. That is not in dispute.
That is,
Now, from this point to reach this road, through which survey number he has to pass? You tell us. You say there is an alternative road. All right, alternative road passes through which survey number? And where it is pleaded in the return statement. You should read from return statement as to from which point the alternative road suggested by you starts. And it passes through which survey number, and at which point it reaches the main road. So when you raise the defense of alternative road, must give the contours. Just saying that there is an alternative road, that is not sufficient. You must point out where exactly it starts, it passes through which survey number, and reaches which point.
the alternative road existence has come in the picture.
All right, now let me understand. Let me understand. All right.
Mouth also it had come.
All right, let me understand. Which is the alternative road which you are suggesting? Now the court has to say that there is an alternative road. The court must understand that alternative road which is suggested by you is running through a particular place. In which place it is running? Your defense related to alternative road can't be vague. It has to be very specific. Alva.
There is some labs in there, no doubt. But
At the end of the day, is your brother, Alva.
not that, Milan. In fact, no doubt on principle, no doubt, Milan. But when it comes to the legal question, Milan, one has to establish Milan the necrotic whether he loses or other one gains.
Commissioner report says the road which is claiming is in existence. The commissioner report.
But so far as this road is concerned, no. But the alternative, if I am able to show that there is an alternative way, and to some extent,
All right. Now read from the written statement for your satisfaction. Again, I'm hearing you. Read from your written statement relating to the alternative road. Where you have stated.
The statement is also lengthy also.
Huh?
There are 3 minutes, 20 is a long-time resident of Mumbai. Never used the alleged call. It's about 2004. It has been demanded. This additional pathway, alleged that is suit pathway, all along the plaintiff and his predecessor were using other pathway available to him. His predecessor.
Just a second. Come to the last 3 sentences in first page. In the said suit, this plaintiff as defendant had made an application for appointment of the court commissioner, advocate commissioner for local inspection. So you are the defendant in that case.
Plaintiff.
So in the said suit, this plaintiff as defendant, yes, all right. This plaintiff as defendant had made an application for local inspection. And the advocate commissioner appointed by the court has carried out the commission work at the instance of the plaintiff himself and has filed a report also. In the said report, the pathway being used by the plaintiff have been clearly illustrated and marked in the plan annexed to the said report. So you are referring to the commission report in the earlier case, and you say that alternative road is marked. Where is it? You are referring to the report of the commissioner in your written statement.
This is the report.
No. You are admitting this commission report.
No, I have one cross-examination.
All right. In your defense, in your written statement, you say that commission report in the earlier case reveals the existence of alternative road. Where is the alternative road in the report? To say that there is an alternative road, you are referring to the report of the court commissioner. Court commissioner's report doesn't say about alternative road. So you can't traverse beyond your written statement.
I try to.
You have put in your best effort. There is no doubt about it.
Even Millard, from his mouth, Millard, commissioner, he has tried to get some sort of this one, but he said, my lord, I have not said it. So ultimately, my lord, whether the, no doubt, my lord, I have not filed a objection to that and or ask for
No, forget about filing objection. In your written statement, you have taken the defense, you have taken shelter under the report of the old commission.
So this is the alternative route, my lord, that is
No, alternate,
just
that's what I'm asking. See, your defense is based on this commission sketch, this commission report. So show from this sketch, where is the alternative road for the claim?
that is GHIJ, my lord, that is over
That is in your land.
over part.
JHIJ in your land.
Even that is just now we have discussed about this.
Heard the learned advocate appearing for me.
One sub.
All right.
Statements are there, my lord, of course.
Good. On each point,
Like to that necessity, my lord, pathway.
you must
whether
you must
absolute
establish,
necessity.
you must establish that there were no other alternative way. Yes, establish. Which paragraph?
His case was that, my lord, there was no other road. But still, my lord, he has to establish. That is, I will just read, my lord.
Which paragraph?
15 onwards it starts. The first one, my lord, para 10 minutes. Other judgments have been referred there, my lord. How to deal with the situation.
Which page you want me to read?
Para 10 minutes.
Page number. Yeah, bottom is the page number is the bottom.
3. Page 3.
Heading.
Top, my lord.
Oh.
That is the first judgment, my lord, there.
Both written statement filed by the defendant, there is no pleading.
There is no pleading of easement of necessity. What they pleaded was that for the last 30 to 40 years, they and their creditors have been enjoying the right of way, and they are also making use of the same. We may note that the courts will have concurrently held that appellants or their creditors have no exclusive right of easement. That means the claim put forward by them, namely they have been enjoying the pathway in question for the last 30 to 40 years, is not true. Of course, paragraph 3 of the original statement, they have stated that they have no other, that is plain one. That by itself is not properly sufficient to acquire the easement necessity. The appellants must have alleged and proved that their property as well as the plaintiff's property belong to common owner. By virtue of division, disposition, transfer, the common ownership has been divided into various tenements, and consequently they are entitled to right of easement. Absolutely, there is no pleading in that regard. Even when the second defendant.
Just a second. Just page number 4. Plaint. The above said AB Nadekanta and CA pathway is the only access to reach the suit property. They say it is the only road.
But in the commission report, it has been.
No, this judgment is not applicable because he has pleaded.
Pleaded, I'll just go to the plain.
I have read it. Page number 4, para E. And forget about easement of necessity. There is also a pleading related to easement of prescription. So he need not establish that there is no other road.
He has to prove that minimum 20 years plus 2 minutes.
All right.
That is not there.
He says, no, he says,
very much necessary.
no, he says,
Lower appellate court says there is no.
he says he is using the road for last 67 years.
That is a statement, my lord. But in your lordship can see.
You cited, no,
I just read.
you cited this judgment to show that there is no pleading. Pleading is there.
Not only that, my lord, that is one judgment. There are several judgments have been quoted there. Just go through.
So on which point you are trying to cite this judgment? Tell me.
Because even mere pleading is not sufficient.
All right.
Has to be shown that
Understood.
the absolute necessity is there also there. Because the courts below, my lord, ultimately, my lord, they said it may come under necessity and also under prescription. So both can't be there because prescription it goes. Then necessity, my lord, whether
So,
it is absolute necessity.
Last sentence, the plaintiff has every right to make use of the set pathway to reach the southern Nadekanta, and it is the only access to reach Barkur town as an easement of necessity.
So here, my lord, alternative, no doubt, my lord, in the sketch it is not forthcoming. But still, my lord,
So there is a plea. There is a plea. Don't argue on the point that there is no plea. There is a plea.
plea is there, my lord, but
you can argue that there is no evidence.
So far as it, prescription is concerned, my lord, even the last will ever 2005 Supreme Court, my lord, the pleading must be very, very strict in sense. Because other person's property is being.
All right.
So far as prescription is concerned, I will just read, my lord.
Sir, only one question. Let us not get into those technicalities. You take a defense under the old commission report. And you say that in the old commission report, alternative road is suggested. Where is the alternative road in the old commission report which you are relying upon?
No, there, I will have to stop, my lord. Anyhow, but the thing
At
is.
the level of High Court, one should stop at a particular point of time. You have done your best effort, no doubt. Every advocate can't win all the cases. Some cases you win, some cases you lose.
Even so far as pleading is concerned, madam. No doubt, my lord. If, my lord, the pleading as well as the evidence is concerned, there is no alternative road at all. Then, my lord, I can't argue, my lord. There is nothing to argue also. Here, my lord, there is some light.
No, just a second. Let us narrow the discussion. He files a case claiming right of easement of way in your land. Your defense is there is no such road. Road is elsewhere. That is your defense. He must establish the road is in your place, right? In your property. For that, he relies upon the report of the commission. Now, your defense is no, that is not the road. Road is elsewhere. Where is the document to show that there is some other road for it? As simple as this. And to make the things worse, you also rely upon the same commission report.
Commission Mouth Melody did come Melody, there is an alternative, but I have not mentioned. So to that extent, commission report is also lapse is there, Melody, but still Melody. But anyhow, Melody, so far as
how long you want me to hear this matter?
Pleading.
How long you want to hear this matter?
Just 10
all
minutes.
right.
10 minutes.
All right.
Just
all right.
Yes.
Yes.
So far as fact is concerned, it's clear.
Yes.
So far as pleading is concerned. Right. Section 15, right of access. Who prescription, plaintiff not who be using access to house as a right in who property of dependents for more than 20 years. Moreover, the plaintiff had access to house on southern side which was being used by her for a long time. Claim as to the access through property of dependents and not tenant. So here also, my lord, alternative road was there. Now he stopped and using this. So far that para 10 is the relevant para. This.
Yes. And 5 Supreme Court para 10 only is concluding portion. In the result, we allow the appeal.
9. We have gone through the judgments of trial court and the appellate court. That high court, we have gone through the evidence which is found. It is more than clear that there is no specific government.
So there was no specific government in the plaint. See, in this case, listen. In this case, there is an government which says that they have been using it openly as of right for the last 67 years. What else you require?
But your lordship kindly see the next para D, my lord, there, just wait. Though he says, but the specific right started from 2003. my lord. That's why, my lord, that is a D, my lord, your lordship just. The last, my lord. As per the compromise dated 2/3/2003, the suit property was allotted to the share of the plaintiff. Since then, plaintiff is in absolute possession and property. Certain portion of 35 now and subdivided so and so, which is allotted to different so and so.
See, what has happened is before 2003 partition, the property was joint. Both of them are using it jointly.
But that road was not there.
They are using it jointly, sir.
Alternative road was there. Thereafter, my lord, he starts claiming.
Up to 2003, it was, up to 2003, there was no question of claiming easement because it was his property, joint property.
There was no road actually.
It was
Then
his-
he started, my lord, he stopped earlier. That is my case also. Because if both are using that road even before partition, my lord, no doubt, my lord. His case is somewhat.
Yes. So the trial court decreed the suit based on easement of necessary prescription.
Prescription. Prescription.
First appellate court, first appellate court.
First appellate court looked at the trial court hold because regarding that question is helpful, because the other suit was already filed. When we see the
Then first appellate court in para 12, my lord.
Just a second. The property is allotted to you in 2003. How can you claim right of prescription in 2006?
that is
20 years prescription has not. No, prior to 2003, it was a joint property. There is no question of you exercising right of
Yes.
easement.
till 2003 onwards, when the public read
No, understood. Question is like this. Prior to 2003, it was joint property.
Yes, all of us. The house is on the northern side.
Now, where do you say that this road was in existence even prior to 2003? So let us assume, just a second, sir. Let us assume prior to 2003 that road was in existence. Then you are not,
It's a pathway.
all right, pathway. Then it is not a case where you are exercising your right of easement because it was your property, joint property.
Yes, it is a joint property of the plaintiff and the.
In that event, you cannot exercise right of easement on your own property.
Subsequently, there was a partition.
Understood. In 2003, partition took place. So to acquire the prescription, easement of prescription, 22 years must elapse.
20 years must.
22. 20 years
Plus 2.
and the 20 years should end 2 years prior to the filing of the suit. So that period has not expired. That condition is not fulfilled.
It was filed in 2006. And that is why, my lord, in action, he may be.
No, you are not understanding the court question.
My lord, that period of prescription
Yes.
is not complete is what the court is. For that, the answer is found in.
There can't be any answer at all. 2003 was joint.
2003, it is.
So in your own property, you can't exercise easement. Heard the learned advocate appearing. Matidya? Heard the learned advocate appearing for the appellant, as well as the learned counsel appearing for the respondent. The suit in OS number 193 of 2006 on the file of Civil Judge Junior Division. Yavaru? Kundapur.
Second additional civil judge.
Kundapur was decreed holding that the plaintiff has acquired easement of pathway over the land of the defendant. And consequentially, the relief of injunction is also granted in favor of the plaintiff. The defendant has filed this. Defendant filed a regular appeal. RA number
71 of 2008.
71 of 2008 on the file of senior civil judge Kundapur. Said appeal is also dismissed in terms of judgment and decree dated
23/9/2008.
23/9/2008.
Sorry, 16/4/2014. 16/4/2014.
16/4/2014. Stop. Echoed by the concurrent finding of the trial court as well as the appellate court, the defendant is in regular second appeal. Stop. This appeal was admitted on
Admit ಆಗಿದೆ.
ಆಗಿಲ್ವಾ?
Admission ಗೆ ಬಂದದೆ.
ಈಗ ಅಡ್ಮಿಷನ್ ಆಗಿದೆಯಾ? ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ ಆಗಿತ್ತಾ? ಆಲ್ ರೈಟ್. The plaintiff is claiming right of way. There is no dispute over the fact that the plaintiff and defendants are brothers, Allah.
Fathers are brothers. Cousins, they are first cousins.
There are no dispute over the fact that the father of the plaintiff and father of the defendant were brothers.
Brothers.
Partition took place in the family of plaintiff and defendant in terms of decree passed in OS number, compromise decree nadu. Compromise decree passed in OS number
535 of 95
535 of 1995.
on 20th March 2003.
The compromise was entered, a compromise decree was passed on 30th March 2003. Yes, full stop. The suit A scheduled property is survey number 35/24A,
Measuring 32 cents.
measuring 32 cents, and the suit B scheduled property
35/24B, measuring 25 cents.
ಎಲ್ಲಿದೆ ಅದು? ಬಿ ಶೆಡ್ಯೂಲ್ ಇಲ್ಲಲ್ಲ?
ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಿ
ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲ, ನಿಮ್ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ.
ನಮ್ಮ ಲ್ಯಾಂಡ್ ಅನ್ನೇ ತೋರಿಸ್ತಾರೆ.
Where is the land of the dependent in the plate?
At C, that in the oral partition plaint C, paragraph C. 3C, that in the oral partition, the northern portion of survey number 35/24 measuring 32 cents, consisting of the coffin building was allotted to the share of the plaintiff, Chief Paul Suarez. The said portion hereinafter called the suit property now stands subdivided as survey number 35/25/24A. In the latest extract of record rights in the above said partition, the southern portion of 35/24 to the extent of 25 cents has been allotted.
Just a second. 35/24A belongs to whom?
Belongs to the plaintiff. 24B belongs to me. In the schedule given.
You are not only the best point available to you. ಏನೇನೋ judgment ತರ್ತಾ ಇದ್ದೀರಾ?
Kindly see the prayer. For a declaration that the plaintiff has acquired easement right to make use of the suit pathway and Nadakanta of the width of 3.5 feet over the southern and western portion of survey number 35/24B of Kechur village to reach the plaint A schedule property from Barcourt town by prescription necessity and mammon.
This suit issued property belongs to the plaintiff. Yes. And in the prayer, the suit B scheduled property is described, which is bearing survey number 35/24B of Kanchur village, Taluk Kundapur. Full stop. It is further stated that the pathway over which the easement is claimed is measuring 3.5 feet in width.
Width.
3.5 feet. 3.5 feet width. Full stop. It is further stated that
The pathway starts in the property bearing survey number 3524A belonging to the plaintiff and reaches up to Barkur Town Panchayata.
Barcode town. To reach the plaintiff scheduled property from Barcode town.
The prayer further says that the suit pathway is in between the plain A scheduled property and Barkur town. Alva. Stop. This is not properly described. This is not the way to describe the property in a suit for easement. Stop. The plaintiff claims that this is the only way to reach his a house from Barkur town. Admittedly, survey number 35/24B belongs to the defendant. Stop. This property is plotted to the share of the defendant in the partition of 2003. Wow. Next. The plaintiff claims that there is an attempt on the part of the defendant to close this pathway. On appearance, the defendant has filed a written statement. The defendant has taken the contention that earlier to the present suit, one more suit was filed in OS number 204 of 2004. ಯಾರು ಹಾಕಿದ್ದು? ನೀವು ಹಾಕಿದ್ದ ಅದು? ನೀವು ಹಾಕಿದ್ದ?
Injunction.
OS number 204 of 2004 in respect of survey number 35/24B against the present plaintiff. Stop. In that suit, the present plaintiff was the defendant and he made an application for appointment of court commissioner. The application was allowed, court commissioner was appointed and he has submitted the report. The defendant would submit that in terms of the said report, there is an alternative way available to the plaintiff to reach his property from Barcode town. As such, the suit claiming easement of necessity and prescription is not maintainable. The trial court has decreed the suit and the reliance is placed on the report of the court commissioner, which is marked at exhibit
P7.
P7. Yes. Stop. The appellate court has also placed reliance on the said report and has come to the conclusion that the suit way is in existence. The plaintiff has got a easement of right of way over the land of the defendant and appeal is also dismissed. The defendant who has placed reliance on the report of the court commissioner has filed objection to the report of the court commissioner and court commissioner was examined. Yes. The objection hakkalikilla. Objection beda. The court commissioner was examined and cross-examined by the contesting defendant. Full stop. The court commissioner sketch at exhibit P7 would reveal the existence of pathway claimed by the plaintiff. The alternative road as claimed by the defendant is not found in exhibit P7. The cross-examination, an attempt is made to establish the fact that when the court commissioner visited this spot, which year Hogidu? In the year 2004, an alternative road was available and same was not noticed by the court commissioner. Stop. The learned counsel for the appellant would submit that the answer given by the court commissioner in the cross-examination would give a hint that there was an alternative road available to the plaintiff in the year 2004 and that is not noticed by the court commissioner. And based on the said evidence of the court commissioner, it is contended that the defense raised by the defendant relating to the alternative ways established. This court has considered the report of the court commissioner.
3 minutes there is a partition. From that day, 20 years old.
Easement of necessity is what?
This court has considered the evidence given by the court commissioner in the cross-examination. The defense of the defendant, written statement of the defendant is in the cross-examination, the court commissioner has stated that the alternative road which is suggested by the defendant is not noticed by him while conducting the spot inspection. It is further stated that there were some marks which indicated that an alternative road was used by the defendant in the said suit, and same was not marked in the sketch, which is at Exhibit P7. Full stop. This evidence of the court commissioner has to be understood in the light of the sketch which is produced by the court commissioner, and also in the light of the defense taken by the defendant in the written statement. In the written statement, the defendant has taken shelter under the Exhibit P7 commission report. The defendant in the said written statement has taken the contention that the alternative road is marked by the court commissioner in his earlier report. The report is very clear. Only one road is found, and that path passes through survey number 35/24B, which is admittedly the property of the defendant. From the sketch, it is also apparent that survey number 35/24A lies on the northern side. The Panchayat road, which is running east-west, lies to the south of survey number 24B. So from the sketch, it is apparent that plaintiff, from the sketch, it is apparent that the plaintiff, in order to reach the Panchayat road, to reach Barkur town from his property bearing survey number 35/24A, has to necessarily pass through the pathway passing through survey number 35/24B. The finding of the court commissioner on question number 6 is also very clear. The question number 6, the finding of the court commissioner on question number 6 is extracted below. Page number 48. So from this, it is apparent that the plaintiff has no other access to reach the Panchayat road from his property bearing survey number 35/24A, other than passing through survey number 35/24B belonging to the defendant. The learned counsel for the appellant would also submit that the plea of easement of prescription is not available to the plaintiff, as the partition took place in the year 2003 and the suit is filed in the year 2006. To establish a plea of prescription, the plaintiff must establish that he has been using the road for a period of 20 years, and those 20 years should end 2 years prior to the filing of this. It is also a submission that the right of use of road, use of pathway should be as of right and hostile to the interest of the real owner, and that ingredient is missing in the evidence. As such, the trial court could not have granted a decree for easement of prescription as claimed by the plaintiff. There is substance in the contention raised by the learned counsel for the appellant. Since the partition has taken place in the year 2004, in a suit filed in the year 2006, the plaintiff could not have claimed a right of easement of prescription in respect of pathway in the land of the defendant. But if the plaintiff is carefully perused, it is apparent that apart from plea of prescription, the plaintiff has also claimed easement of necessity. It is a specific case of the plaintiff that except the suit road, there is no other road. Under these circumstances, this court is of the view that though the plaintiff is not in a position to establish plea of prescription, the plaintiff is in a position to establish plea of necessity as far as suit pathway is concerned. The learned counsel for the appellant would also place lines on the judgment of the apex court in the case of Justiniano 2005 SC 236, and also the judgment of Madras High Court in the case of so and so. This court has considered the ratio laid down in the aforementioned cases. In the aforementioned cases, the Honorable Apex Court as well as the Madras High Court have held that there must be a proper plea and evidence to claim, to establish, to claim a right of easement. In the judgment cited by the United Council for the appellant, reported in AR 2005, Supreme Court 236, the Honorable Appeals Court has noticed that the plea of alternative road was established only. AKSL. The plea of alternative road was established by the defendant. As such, the decree for easement of necessity was not granted. In the instant case, the alternative road is not established by the defendant. On the other hand, the plaintiff is in a position to establish that except this road pathway, there is no other pathway to the plaintiff to reach his property from the Panchayat road. Under the circumstances, the ratio laid down in the aforementioned judgments are not applicable to the facts of this case. For the aforementioned reasons, this court is the view that no substantial question of law would arise for consideration in this case. Accordingly, the appeal is dismissed. Just a second. It is also noticed that the plaintiff has not affixed a hand sketch along with the plaint. He has described the suit schedule property belonging to the defendant in the prayer. Since the court commissioner's report is found at Exhibit P7, discloses the existence of the road, the report of the court commissioner should be treated as part of the decree.
See, receipt of the court commissioner is in 2004. That is
2004 alva.
2003. Seven.
2006.
It was in 2006. Six.
Very good. 42 now.
Hearing matter. Number 43. C. Shivram.
The correspondent.
First respondent.
None appeared for the appellant. This matter next. Nale baratte. Nale Monday. This matter Monday. Monday.
Please.
44. Number 44.
Any report? None appears. This matter Monday.
Number 45. Vastavji.
Yes, concurrent finding. And it's the second appeal of independence.
Yes.
Suit for a declaration of title and permanent injunction.
Yes.
Plaintiffs have filed.
Based on what? Declaration of title based on what?
Based on that, the original owner of the property was no more. He is their father. There is a dispute.
Based on succession. Based on
Based
succession.
on succession. And this also succession for the first defendant that is the wife. The relationship of the first defendant with original owner is denied by the plaintiff. So also the defendant has denied the relationship of the plaintiff with the original owner.
You dispute the plaintiff's status as son. Defendant is disputing your status as wife.
Yes. In the case of the plaintiff before the courts below Malad, they are the children of one Pujari Lingappa, who happened to be the son of one Pujari Lingappa. And there are four plaintiffs. First plaintiff is A. Pujari Lingappa. He claims to be the son of Pujari Lingappa. He is also Lingappa, his father is also Lingappa. And in the caste cycle itself, they have disclosed that and revealed that. The plaintiff number 2 is the resident of Vijayalli village where the original Pujari Lingappa was residing. And rest of the plaintiff, that is 1, 3 and 4 are residing in both the places. Both the places means one is the place where the original Pujari Lingappa was residing, namely Vijayalli, and another village which is situated in Madakshira Taluk, Andhra Pradesh. Komarinalli. It's a caste title itself.
Now, court has said that appellant is not the wife.
Appellant is not the wife. Second defendant is the purchaser of the property in the year 1989. Before filing the suit.
From whom?
From first defendant.
First defendant.
Yes, from appellant.
When this Pujari Lingappa died?
As per the plaintiff's contention, he died in the year 1984-85. The revenue entries were effected in the name of first defendant. Synopsis I have prepared, sorry, madam. First the synopsis.
Yes. According to plaintiff, who is their mother?
Their mother was Rangamma.
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 When she died?
That was not brought on record. They didn't say. But however, it is subsequent to Pujari Lingappa, father. Father died in the year 1985.
So mutation was in your name.
My name in the year 1986 onwards.
Whether they were notified? They were not concerned. That is your stand. Yes. All right. All right. All right.
However, my contention was
Just
that,
a second. Did they file application to mutate their names?
no, they have not filed. But they have challenged the mutation order. Thereafter, the assistant commissioner remanded the matter to Nada Kacheri Tahsildar once again. Nada Kacheri Tahsildar has effected the entries in the name of the plaintiff after remanding the matter. Against the said order, he preferred the defendant number 1 preferred the appeal before the assistant commissioner. Assistant commissioner has thoroughly examined and collected the details of the plaintiff and the defendant. And in this order, he held that the plaintiffs are the residents of Madakshira Taluk, Komarinalli village, Andhra Pradesh, and he has collected the voter list also. He has made an observation in this order. And thereafter, he restored the entries.
Yes.
In the name of the first defendant.
Yes. Then what happened?
Then they approached this honorable court.
All right.
In writ petition. Interim order of stay was granted initially. And thereafter, to some extent, it was modified. Finally, it was disposed of by this honorable court, holding that it's subject to
Delegating them to civil court. All right.
Till then, matter to be.
Yes.
Entries to be restored in the name of the first defendant.
All right. On what basis the trial court has granted decree for declaration of title?
Before that one, sir. All the way.
Sorry.
All the way till filing of the present suit. There are so many tribes, litigations, before the quasi judicial authorities were held. The themselves has stated that Lakkamma, who is the first defendant, is wife of Pujari Lingappa.
Just stated.
They have stated. Plaintiffs themselves have stated wife of Pujari Lingappa. On the other hand, they stated that she is not the resident of Vijayalli Pujari Lingappa. She is from Olikere, a village which is 22-25 kilometers away from Vijayalli. Vijayalli village is the place where the original Pujari Lingappa resided. Plain governments, neither in the evidence, nowhere it is stated that Pujari Lingappa was also residing in Madakshira. Was the resident of, there is no dispute at all. That their plaintiff's documents itself establishes that defendant is the husband of Pujari Lingappa. Only as your lordship poses the question with regard on basis what basis they have passed an order, the trial court has held that these She had an applied as if there is no application on record. There are 3 orders as if passed by the revenue inspector and the Tahsildar, wherein it is contended that it's a document produced by the plaintiff exhibit P 28, 31, 32. And one measure was drawn on the basis of the statements made by the plaintiff, not by the defendant or the villager, somebody else.
So whether school records are produced to show
They
that
cannot produce. They are all literates. They made their signatures.
birth certificate,
Nothing is produced.
ration card,
Ration card is not produced.
voter list,
Voter list is produces. It is pertaining to the year 98, and another is 93, 83. 83 voter list is not very clear with regard to their residence. We have admitted that second plaintiff, Muddanna, brought by the first defendant and her husband Pujari Lingappa since they are issueless. On the other hand, she contended that the sister of the plaintiff, one Muddamma, was given in marriage to the brother of the first defendant, was Madakshira. Confusion is what you can see. Plaintiff's father, Madakshira, was also Pujari Muniappa, Pujari Lingappa. The plaintiff's first defendant's husband is also from Vijay.
This is a case where the real truth is will be known only to the parties.
Yes, the document has to speak. You are asked to one inference can be drawn by your one widowed somewhere residing as contended by the plaintiff.
She won't lay a claim.
How can she 25-30 kilometers away she came back without any relationship and claiming a property of some third person?
The same analogy applies to the plaintiffs also.
Yes, for them, we have not admitted that they are some children of Pujari Lingappa. But in the other way,
No, there are 3 plaintiffs, right? 3 sons,
4 plaintiffs.
4 plaintiffs.
All plaintiffs. It is a one thing is admitted fact that my first defendant.
Is it not possible to have a settlement?
Settlement proposal ಮಾಡಿದೀವಿ.
Recognize each of.
900 fantastic.
Recognize
We were not speaking before.
No,
that.
recognize each other's claim.
Yes, that's why one submission. We have given an offer. So half of the portion of the property is sold in favor of the second defendant. Second defendant in the year 1918 before filing the suit. There was
Second defendant is also in appeal now.
yes, it's the second appellant number 2. Appellant number 2. You are by arrangement of representing both. Since first appellant is died, is legal representative in favor of whom the will was executed was brought on record. Now,
Now, what is your offer?
over 50% here, Maharindra between only covered with the
But I shall find out. Earlier also, not compromise talks did held between the parties, it did not materialize. And they completely say that they have nothing to do.
So I haven't gone through the papers yet. Ultimately, the court may not know the exact truth, real truth.
Yes.
In a case like this.
But not on the basis, of course, on the basis of the evidence.
We can't go for DNA test in this case. Right.
That either the DNA test or the any other.
Otherwise, it would have been the best piece of evidence.
1956, one document is my in favor, registered document I have got the first defendant as
That is
in
why
1956 deed itself, which says that she is the wife of Vijayli Pujari Lingappa, not Ligere Pujari Lingappa, Vijayli Pujari Lingappa. Before that, in the year 1956, they were all not at all in picture.
Yes. Third, the learned advocate for the appellant in part. Since the court time is over, afternoon I have got a combination sitting in division bench. This matter for further hearing on Thursday. In the meantime, try to.
I shall also not work
All
out.
is in my.
Offer appears to be very reasonable.
I shall convince.
No, see, she's only trying to settle purchase others, protect the purchaser.
Yes, madam. However,
And even, sorry, even legal application filed for devolution of interest is also not, the findings are given by the trial court. That will is not. That's also.
Who executed the will? Who executed the
The
will?
first defendant has executed the will in favor of one Shivan
she was alive.
when she was alive. 3 months prior to her death.
Question,
Unregistered will.
Wife executed.
question before here, my lord, the
D1.
right of the first dependent will be decided. It's not the person who claimed as a legal representative, first dependent. Said about it.
Right of the first.
First dependent has to be dependent. Either way, we will be legal representative or some plaintiff who.
She has sold all the property.
No. 50% of the property she sold. Your lord's mechanism, as I contended, she was. The plaintiff number 2 was brought for performing puja. ಅವರಿಗೆ ಅರ್ಧ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟು ಇವ್ರಿಗೆ ಅರ್ಧ ಮಾರ್ಬೇಕು ಅಂತ ಗಂಡ ಹೆಂಡತಿ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಂಡು ಪೂಜೆ ಮಾಡಕ್ಕೆ ರಿಲೇಟಿವ್ ಅಂತ. As soon as the first dependent died, the dispute starts. They started claiming entire property. Before disputing itself, the property was sold in favor of second dependent in the year 89. Dispute started in 92.
Right.
Till then, they didn't claim even the revenue entries whatsoever, limitation, nothing in their main claim.
Yes.
Here is the problem.
Main point on which both the courts have held is that Pujari Lingappa's father is one Muddanna, but they claim on a different person. So that's the exact reason why, Milad, and also she's taking the pension of her
What
husband.
is your answer to the sale deed?
Milad,
Sale deed at undisputed point of time.
Milad, sale deed at an undisputed point of time is in the name of Pujari Lingappa, son of Muddanna. Exhibit P1. Original has been produced. Milad, ultimately, Milad, the defendant, she has admitted that they are the children of Pujari Lingappa, son of Buddappa, and Rangamma is the wife. That they have admitted. Milad, second, Pujari Lingappa, whether Pujari Lingappa husband, father's name need to be seen, Milad. That will.
I think I have adjourned the matter.
Yes, please, Lordships.
Try to explore the possibility.
Milad, that I shall do it. Milad.
Thank you.
Yes. Have it? 31. The request of Honorable Counsel for the appellant. Justice Matron. 14th November.
53.
File number 3. What is that? Number 3.
But when the RSC was pending, you were there faster. You were not parties to the RSC second. But we were purchasers pending a line. And during the entire course of this not for their extended for more than 30 years. You were never brought.
What is the office objection? The death certificate is not correct. They are producing it tomorrow.
I will try and have it also. I try and review it tomorrow. It's not like trying. Please evaluate the exact date.
Let it come on Monday.
All of them. I will immediately bring it.
Is on which date now? 21st. Monday how ಬರುತ್ತೆ? Alert Counsel for the application for stay. ಹಾಕಿದ್ರಾ? Tomorrow.
Serial number 12, your lordship, has been passed over. And comply with the office objection. It's time to come.
Request of Alert Counsel for the appellant next time granted to remove the office objection.
We'll put 37 my one.
Contact for fourth or you are trying to submit settlement.
ಆಯ್ತಾ?
Parties are ಆಗಿಲ್ಲ ನಾನು ಕರೆಸಿ ಮಾತಾಡಿದ್ದೇನೆ.
One at a time.
Possibility of settlement does not be happen because they are not.
It is submitted that the matter is not. It is submitted that the matter is not settled. This is matter for final hearing.
It's already heard on the last patient.
Now the point.
And all the property is not included in the document.
The property
Anyway,
stands in the
there
name
is
of.
some more argument is there.
That is exhibit D1, my lord, as far as that agreement is concerned.
Is this matter on 7th? 7th.
Serial number 53.
File hearing, number 53. Hearing agidya adu? Manna hearing agidya?
Mr. Lordship, kindly, my lord.
Arvind Jayaprakash.
Jayaprakash sir, unmute
No,
ಮಾಡ್ಕೊಳ್ಳಿ.
he was in VC, my lord.
Yes, Mr. Jayaprakash.
Jayaprakash sir, unmute ಮಾಡ್ಕೊಳ್ಳಿ.
Unmute your mic.
Yes.
Yes. Serial number 53. There is a request to adjourn the matter by the counsel for respondent.
Yes.
ಮೊನ್ನೆ ಪಾರ್ಟ್ ಔಟ್ ಆಗಿದೆನಾ?
ಇದಲ್ಲ 49 is the part.
53 or no objection?
No objection.
Which date you want? After 2 weeks, 2010 matter. 53. This matter after 2 weeks.
No, not.
So 6-7 pending is that is the difficulty. 2 weeks after 2 weeks.
The Lordship, kindly, my lord.
Yes.
48, my lord. May I request your Lordship to have it a third, my lord? I want.
58.
Allah, 48. My lord. I have some inconvenience in the afternoon. I was ready morning session.
48 is the new idra?
ಇವರು ಸನತ್ ಕುಮಾರ್ ಇದ್ದಾರೆ, ಸನತ್ ಕುಮಾರ್.
Yes.
3ನೇ ತಾರೀಕು ಮಾಡಬಹುದು.
21. 9. 48. At the request of Learned Counsel for the appellant, this matter on 9.
Serial number 22, my lord. Serial number 22, my lord. I appear for respondent number 1. I have to retire from the case. No instructions from the respondent. Kindly accommodate 1 week time. I have to issue notice to the respondent.
Number 22.
My lord, I represent the appellant, Lord. Serious, Lord, application filed for committing contempt of court, Lord, even though there is an interim order, Lord, they have started construction. Lord, the application is pending, and also I filed application for police protection. They are making, Lord, all sorts of, Lord, illegal method to avoid, Lord, the order of dishonorable court. Lord, though there is an injunction order, Lord, they are doing all illegal activities, Lord, violating the interim order. Lord, the council,
We'll have it on Monday, one day.
Lord, if Lord, the council saying, Lord, he has retired. Yeah, he has not, Lord, filed any application as on this time, Lord, for this honorable court about his retirement.
My lord, I have to issue notice to him.
Can on Monday? Can I visit on Monday?
Lord, Monday, Lord, after second, Monday, Lord, I got some personal inconvenience.
22. This matter on 4th.
Lord, I may be permitted to take notice on the party himself, Lord. The difficulty is, Lord, even on that day also they will make same submission.
Now, which notice?
Lord, the notice on the application I filed, Lord, because I served
Which application?
Lord, I filed application for seeking police protection.
See, now the advocate has not yet retired. You have already served the copy. That is a valid service.
Please, Lord, please.
In the advocate, respondent and respondent.
Please, Lord, please.
On 4th.
4th, great.
Now you have to make certain arrangement before 4th. On that day, you can't say that I'm going to issue a notice.
Yes, ma'am.
Because they are pushing for early hearing. They say there is a violation of interim order. On that day, the application will be considered on merit.
Lord, serial number 57, I represent the appellant. But I am ready, Lord, if it is taken up, Lord, in the evening.
Just a second. Further hearing antidare. 58. This matter on 4th. Yes. At the request of Learned Counsel for the respondent.
57, Lord.
15, 2 weeks. 52 weeks. 52 weeks.
57, Lord.
Yes.
I represent the appellant. I am ready, Lord. Lord, matter is taken up, Lord, after lunch, Lord.
After lunch, I got division bench sitting. Quota number
I'm
5.
sorry, Lord, any other day, except Lord Monday.
After 2 weeks, 2016 matter. After 2 weeks.
Please, Lord.
Serial number 47, my lord.
Yes.
Final hearing.
Yes.
Your lordships are not sitting in the afternoon. Any date may be given.
Madhyana sitting illa. Mr. Mahale,
Any day.
The counsel for respondent is insisting for a short early hearing.
No,
2006
Monday,
matter.
my lord, Monday.
Yes, is this not on Monday?
4 and 55, because no sitting out. So it will be taken on Monday. 54, 54, 55.
Granted out. Both cases after 2 weeks.
After 2 weeks, another earlier application act ಬಂದದ್ದು.
ಹೌದಾ? ಯಾವಾಗ ಹಾಕ್ಬೇಕು?
ಸೋಮವಾರಕ್ಕೆ.
ಸೋಮವಾರ ಕಷ್ಟ ಆಗ್ತದೆ ನನಗೆ.
ರೀಚ್ ಆಗಲ್ಲ.
ನಾಟ್ ಆನ್ ಮಂಡೇ.
ಬುಧವಾರಕ್ಕೆ 54, 55 ಎರಡು.
Serial number 40, my lords.
ಮಾಡಿದೀರಾ? You complied? You have complied? Rank of the party. ಮುಂದೇನಾಗುತ್ತೆ? ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? Who died? Second appellant. See, you have not properly mentioned the rankings of the parties. Learned counsel for the appellant would submit that necessary corrections should be made in the application and office submissions be removed. Application is in time? Huh? Natural errors ಹಾಕಿದ್ದು is allowed. Appellant proposed errors of appellant number 2 are allowed to come on record. Appellant.
My lord, may I kindly pardon me for this late submission. Serial number 55, let it not be on Monday, my lord. There is a direction matter is there on Monday.
55, na?
55. Abu Baker was making a mention now.
Monday ಹಾಕಿಲ್ಲ ನಾನು ಯಾವ ಹಾಕಿದೆ? ಅದೇ mistake.
Monday there is a direction matter is there for me.
ಬೇರೆ ಮ್ಯಾಟರ್ ಇದೆ ಅಂತವರಿಗೆ. ಬುಧವಾರ Wednesday 54 and 51 Wednesday.
40, my lords, passed over. It was passed over, my lord. My lords are coming in the afternoon. We are ready.
No, not coming. Division bench sitting. Yes. What is that matter?
Shanbog, it was heard for some time, my lords.
Monday. 40 Monday.
Please, your lordship. Serial number 49 and 51. May kindly be taken up on Monday.
49 and 51, yes. Yes.
Yes.
Monday.
Yes.
Courthouse, sir? Courthouse, sir? Courthouse, sir? Courthouse, sir?
ಇರ್ಲಿ
ಕೇಳಿ ಸರ್.
ಸರ್ ಸಿಟ್ಟಿಂಗ್ ಇನ್ನೂ ಲೇಟಾ ಕೋರ್ಟ್ ಆಫೀಸರ್?
Hello, sir.
ಹಲೋ, ಸಿಟ್ಟಿಂಗ್ ಲೇಟಾ ಮೇಡಮ್?
ಇಲ್ಲ ಸರ್, ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ, ಬೆಂಚ್ ಇದೆ.
ಸರಿ ಸರಿ ಮೇಡಮ್, ಆಯ್ತು.
ಗೊತ್ತಿಲ್ಲ ಖಾಲಿ ಇದೆ ಸೀಟ್. ಅವತ್ತಿನ ಮಧ್ಯಾಹ್ನ ಡಿವಿಷನ್ ಬೆಂಚ್ ಆ ಥರ ಹೋಗಿದ್ದೆ ನಾನು. ಹೈಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ ತೋರಿಸ್ತಾ ಇದೆ, ಇಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ ನಡೀತಾ ಇಲ್ಲ. ನೋಡಿ ವಿಡಿಯೋ ಕೊಟ್ಟೆ, ಝೂಮ್ ಬಂದಿದೆ, ಇದು ಬರೋದಿಲ್ಲ ಹೊಡೆದ ಯಾರು ಗೊತ್ತು. ಇದ್ರ ಸಣ್ಣ ಫೋಟೋ ಬರುತ್ತಿದೆ, ಇನ್ನು ಕೂತಾ ಇಲ್ಲ ಬಂದು. ಅಪ್ ಮಾಡಲಿಲ್ಲ, ಕೂತಿಲ್ಲ, ಸುಮ್ಮನೆ ಯಾಕೆ ಲೀವ್ ಮೀಟಿಂಗ್ ಅಂದ್ರೆ ಹೊಟ್ಟೋಗುತ್ತದೆ. ಲೀವ್ ಮೀಟಿಂಗ್ ಅಂದ್ರೆ ಹೊಡೆದ್ರೆ ಹೊಟ್ಟೋಗುತ್ತೆ, ಹೊಟ್ಟೋಯ್ತು. ಲೀವ್ ಮೀಟಿಂಗ್ ಹೊಟ್ಟೋಯ್ತು ವಾಪಸ್.
Court officer. Court officer.